Okay, let's do a sound check. One moment. Looks like we are rolling. So, welcome in everyone to a Friday evening, January 31st, for those of us here in the States. January 31st, Friday. Welcome to a Friday night show. And for those of you on the replay, who knows when it is, but you are welcome here. And please go ahead and hit the like, leave some comments below, etc. For those of you on the live stream, please go ahead and join the live chat. The live chat is very nice. I love all my live chatters. They're generally very smart and very kind. So please join the live chat. There's so much happening, and we have so much to get into tonight that we'll be getting started. And not feeling the best. I have be honest with you, I have a fluid in my left ear. So I'm only hearing out of my right ear. It's kind of weird. So good luck with that, Prof. But we'll welcome everyone into the live chat, and then we'll get started. And hey, man, isn't it crazy that another plane crash in Philadelphia? It looks horrible. Looks really horrible. But what can I say? I don't know. It's uh, it's another crazy day. So here we go. Let's see. Make sure I catch everyone that's here because I so appreciate everyone's presence here. So we got Court of Public Opinion, 5 Green Acres, Amy, Tracy Thornton, Rhonda Holton, Oleg Cat, Cosmo, Dawn Steele, Indiana Hanna, Michelle N., Deputy Dog, Stacy Stevens, Pam Sheehan. Happy birthday, Pam. Pam says it's her birthday. All right. And we have Who's Your Daddy 11? Laura Naran. Sweet Dude Shibby. Plain Iron. Heavy Metal Rehab. Amber Light. Mark Ellis. Deputy Dog already said hi. Okay. Ricardo 2. And Sarah. Missouri. Mima of 9. Mino Dino. 26 dead zombies, dude. Kate U. Rambo Bambo. Goddess. Kaleidohope. Marianne. Nicole Watt. We got Rebecca Ann, 1965. Go subscribe to her channel. It's hilarious. Trust me. Carla Ann. We got Northern Star. Jeremiah Grady. CT Girl, 5150. Fur Baby Daddy. Cosmo, we got Carla Ann just became a member. Thank you, Carla Ann. Welcome to memberships. Go check out a video called Train Guy. You should love it. V, Heather Brown, Sandra Rowley, Melon, Deb, Asha Harry. Tracy Thornton just gifted 5 memberships. Hopefully somebody benefited from that. Let's see, 5 Green Acres. Mama J. All right. The Band Via. Plain Iron. That one dude, 75. Faith Ross. What's up, Faith Ross? Gretchen Allen. Michelle N. Okay. Who knows who else? Let's see. Oh, Christina. What's up, Christina? All right. Dumplings, Gammy. Gamma. TJ Bits. All right. Let me know if I missed you. I think I got everyone. All right. Jonathan Smith. What's up? All right. Bonnie Sorby. All right. So I think I got everyone. If I missed you, just drop your name down below. I'll say hello. And what else do I want to do? I want to do something. I want to give something a try because someone told me a little something. Let's see if I can make this happen. All right. Let's see. First, we're going to try this one. All right. Just a moment. Let's see if I can do this. Okay, that's not working. All right, let's see. Come on, baby. Come on. What's going on here? All right. What the hell, man? Just a moment. I'm trying to do something special. Let me try it. Let's see. Be patient. Be patient. Patience, please. All right. I'm working on this. Someone sent me a little message and gave me some advice. I'm trying to work it out here. Let's see. Hmm. 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 Well, I take it back. That's not working. I think somebody lied to me. All right. Well, let's see. They said I could drop gift memberships. All right. Was it Heather? Heather, did you tell me I could leave a guest membership, a gift? I could gift memberships to my chat. Hmm. I seem not able to do it, but I wish I could because I wanted to give you the. It wasn't you, Heather. Oh shoot! All right. Hmm. Okay, we'll forget it. We'll forget it. I tell you what I'm trying to do. I'm trying to do the gift memberships to the chat from my directly from the channel because someone messaged me that I could gift memberships to the chat once a month. And today's the last day of the month, so I didn't want to miss it. Let's see. Nope, it's not allowing me. Hmm. What a shame. So we'll get into it. If you are watching and you have figured out how to tell me how to gift memberships, I have the desire to gift memberships to my live chat so that some of you may get a membership who don't already have one. Um, all right. So, oh, what's up? We got Miss K, Sunflower, Veronica, Help Me Rhonda, Viola Swamp, Steph Mama, all coming into the chat. So, hello. What's up, Niobe? And JJ Falk Jr., all of you coming into the chat. Thanks for coming in while I've been kind of stumbling through trying to figure this out. But appreciate you for being here. Jason Viss, Rhonda Holton, that one dude 75 says, "Great, have a great show." Thank you. All right, yeah, I can't figure out how to drop these memberships. It's just frustrating here. I should ask Pubes. Pubes does it periodically after he begs. Pubes is like, if you give me $250, I'll drop 10 memberships in the chat, or I'll drop 5 memberships. But he doesn't say that you get, I think you get 10 a month to give to your chat members. So. Pubes, tisk, tisk, tisk. Stop pretending, Pubes. All right. All right. What's up, Jan Humphrey, Goddess, Jenny Grohl, Barbara Borman. All right. Northern Star, everyone who's coming in. Thanks for joining the chat. I appreciate that. Now, okay, click the money icon within the live chat, select membership gifting, click gift 5 now. Well, thanks for the instructions. Now, I just tried that. It didn't work. So let me try it again. All right. Try it again, Prof. Gift 5 now. Okay, try it again. Nope, I don't have that button. It only says buy. I can buy them. Nope, I wonder if it's a setting I need to take care of in my settings. Yeah, who knows? So I'll give up on it. I don't want to waste any more time for the show, but hopefully next month. Okay. All right. So where are we? So tonight we're going to talk about the Delphi case. So for those of you new here, I appreciate you coming here new, and if you don't already know about this case, you're going to be stunned. This case here, I've called it Delphi, Indiana Tramples, Man's Constitutional Rights. You've never seen anything like this. I guarantee you. You've never seen anything like this. The state of Indiana has just trampled all over this individual, Richard Allen. Okay. There's so many layers to it. But in all ways, the state of Indiana has basically come together, collectively figured out how to walk all over this man's rights. And from the very beginning, from the PCA and over on to his first interrogation, his arrest, his decision to keep him in prison, in solitary, where he was kept for over a year, abusing him to the point of extracting or coercing confessions, then using those confessions and other information fed to him to go ahead and prosecute him. And in the point, or in the course of prosecuting him, keeping pertinent information, pertinent factual information from the jurors, keeping third-party or any mention of third parties from the jurors, any of the context of the facts known to the public from the jurors, to leave the jurors essentially blind, and giving them only one choice when compelling them to convict someone for the murders of these two little girls, and that was Richard Allen. And unfortunately, all of that worked. And then on top of that, you had a defense team who made many mistakes. Okay, um, people don't like when I say it, but it's a matter of fact. Um, these attorneys essentially were also operating blind. Um, you have to understand how much information was included, I guess, is the word, in discovery. Also understand how much was excluded from discovery, potentially exculpatory information by being deleted, etc., not handed over or handed over reluctantly. The state played dumb, deaf, dumb, and blind this entire time. Um, just absolutely inconceivable. So you had a defense team that was operating blind, a jury that was operating blind and kept ignorant, and when it all came out or worked on through this system, they ended up coming back with the unanimous guilty verdict, which is unbelievable, unbelievable, especially unbelievable when you consider what subsequently came out when one of the jurors decided to come out and talk with one of the podcasts who happens to be part of the PR team for the state, oddly enough. And this juror came out and let it be known that they basically didn't believe any of the evidence. The only thing that they believed, for the most part, was that he was the only choice they had to make. And so they made that choice. And it's just absolutely unbelievable. Uh, and there's so much more exculpatory information than there is information proving his guilt beyond a reasonable doubt. But as you guys know, the point of our system is 12 jurors decide your fate. So this entire thing is contingent upon what you're able to convince the jury of, not what the facts are, not what the public knows, not what the public feels, not what the consensus is, and not what truth has been told. No, it's all about what can you convince the jury of, and can you keep that jury ignorant enough of the facts to convince them of a fantasy? And that's what happened. And for a thing like that, it takes the judge, it takes the prosecutor, it takes law enforcement, and it takes the quote unquote experts. And in this case, against all odds, you had a confluence of all of those coming together to railroad this man and lead this jury straight into a conviction, and it worked. And it's absolutely unbelievable. And I've said so many times, go ahead and arrest me, okay? Because state of Indiana, here's what I am alleging. I am alleging that you falsified evidence. You deleted exculpatory evidence. You manipulated witnesses. You had experts lie for you knowingly. You had witnesses lie for you knowingly. You convicted a man with zero evidence knowingly. And you're upset that the public sees it and doesn't like it very much. Remember this. Remember that after the conviction of Richard Allen, the state of Indiana gave a public press conference at which the head of the Indiana State Police, the grandfather of one of the victims, the prosecutor, they all ran their fucking mouths, their big mouths, and they taunted. Okay, they stood up there on their soapbox and they puffed their chests out and they taunted the public, saying, he's guilty. Don't question us. We would do anything for each other. We're not liars. We're not corrupt. And if you don't like it, leave the country. Yeah. After 7 years of lies, gaslighting, death threats, threats to the entire community, apparent murders, so they will all stand shoulder to shoulder and double down on what is clearly a shameful display of the power of the state being abused to come down on someone they think is guilty, regardless of what the facts of the matter are. And all the inconvenient facts were left out. They made sure to delete. For those of you new to this, just imagine 70 days, including the first full week immediately after these murders, being completely deleted with no accountability for what was deleted. And those deletions pertaining to primarily interrogations or discussions with family members and with the third party perpetrators who were mentioned by the defense as potentially inculpated in this crime. Absolutely unbelievable. It's shocking. You had a timeline that doesn't work at all. Doesn't work. When this fantasy came out, it was apparent to everyone that the timeline does not work. It's been proven that the timeline doesn't work. Yet, they kept that information from the jurors, and the defense failed in rebutting it or addressing it properly. So, like I said, it's a confluence of errors that has ended up with a man's constitutional rights being completely shredded. And at the cost of approximately $4 million, they managed to not only cover up the murders of two little girls, but cause a jury to agree to convict him based on a faulty timeline, zero forensic evidence, and manipulative, lying witnesses, law enforcement, and prosecutors. Guarantee you've never seen anything like this. So this show tonight is especially for those of you who are new. It's going to be somewhat of a quick summary of what I believe are the primary indicators that that his rights as an American citizen and citizen of the state of Indiana were completely trampled, and that basically freedom means nothing in America, because if you have some people who are powerful decide that you're going to go down, you're going to go down. And that's what it is. Okay, so how are we going to address this? Well, let's see. I guess we'll start like this, okay? We'll start like this. All right. Now, people have said this judge is biased. And of course, All the PR team for the state of Indiana has said, no, no, no. She's a wonderful judge. She's great. She kept this case on track. And one of the victim's grandfathers actually said that too. Thank you for the judge for keeping this case on track. All right. So keeping this case on track. And they said, no, the judge wasn't biased. She was just correct. She was steadfast, had integrity, and kept this case on track. Now, what it turns out is that we really don't have any proof or evidence that this judge was determined to imprison Richard Allen for life. But we do have evidence that her assistant, right here, was absolutely determined to have Richard Allen be punished for life for the Delphi murders. And this right here is from a YouTuber to another YouTuber. And this YouTuber says, my source says she's seen all the documents. She says Richard Allen is guilty as sin. She's 100% sure. Now, this is before trial. And wants harsh punishment to happen to him. She was saying how she hopes Judge Gull keeps him in Westville because that's where he belongs. And this is the assistant to the judge. And I've said in my most recent shows, don't you think that this woman would be reflective of what the judge feels? I mean, they do work together full time, 7 days a week or 5 days a week, whatever it might be. Person who works for Judge Gull. Okay, see? Person who works for Judge Gull, my source. You know my source, the one who works for the judge? Okay. So I show you this to indicate to you that if the primary one single sole main assistant for the judge feels that he's guilty as sin, she's 100% sure, wants harsh punishment to happen, hopes judge keeps him in Westville because that's where he belongs. If she feels like that, don't you think that the judge is probably not too far from that? And by the way, how has she seen all the documents? I mean, isn't the judge only supposed to see the documents that are filed with the court? I mean, this was quite a while ago. This was pretty much when only the PCA had been released. So how in the hell has this judge's assistant seen all the documents? All right, but it's worse. Okay, it gets worse because what's up, Criminal Network? What's up, Say What? What's up, Jalen? All right, everyone. Kayla, 4 Pits. What's up, everyone coming in? Thank you. We're just getting started. All right, so we're going to kind of start here and go backwards. But here you'll see the motion to compel. No, I'm sorry, motion to compel. I was reading that earlier. So sorry, it's on my mind. That's another bomb drop that we'll cover on a separate show. Listen, very soon we're going to do a deep dive on the motion to correct error. I'm sorry, on the motion to compel. Okay, and we're going to do a deep dive on Stacey Eldridge. Okay, so apologize for those things are in the back of my mind because I've been working on them today. So we're going to do deep dives on Stacey Eldridge and on the motion to compel, but that's coming. Okay, so but here we're going to talk about some fatal errors. Okay, now there are four main points that were most recently addressed by the attorneys to the court. Okay, and we're going to go through these four before we go into more. And you like how that rhymes? Right on time. I didn't mean it. All right. All right. So all four of these are quite alarming. Alarming is a downplay on how alarming these are, but that's the best word we got. Okay, alarming. All right. So the first thing was that in violation of the Sixth and 14th Amendment, and look, let me stop it. Okay, I always have to do this. Remember, you're starting with a judge who already feels he's guilty. She's seen all the documents. He's guilty as sin, wants him to go away to Westville forever, which they did. Okay, and that's what we're going to get into right now. Okay, but you're starting with extreme bias. And that starts with the arrest of Richard Allen. Okay. There's zero ethics. Okay. I see what you're saying here in the chat. No, there's zero ethics in this. That's what we mean by tramples his constitutional rights. Because there's not ethics anywhere. There's no ethics in the actions of the Carroll County Sheriff's Office. Okay. There's no ethics in the Indiana State Police's actions. And trust me, if you want to challenge me on that, let's go back and we'll bring up some specific examples. Trust me, you don't. Because the minute we start talking about Jerry Holman, you're going to shut the fuck up. Okay? You got a complete lack of ethics in the prosecutor's office and a complete lack of ethics in the judge's chambers. Okay? So when you want to talk about a lack of ethics, it's all the way around. As a matter of fact, the only ethics I've seen in this comes from the defense teams or the defense attorneys. Okay, so all of the particular individuals involved in the defense of Mr. Richard Allen, I would say that's about the only place I've seen any ethics displayed. And I have to say, even in the defense investigators. Okay, so on all in all ways, from the defense side, I've seen a lot of ethics, which to be expected, and that's the only ethics I've seen. It's alarming. It's absolutely alarming, and remember that this judge and this prosecutor and these people tried to jail these attorneys. Okay, they tried to have us unalive ourselves out here in the real world by sending the troll farms at us, threatening to kill us, okay, accusing us of horrendous crimes. They pretty much caused Robert Kyle Fortson to kill himself by putting their foot down on his neck. They caused a lot of harm out here in the podcaster community. They've caused some to go broke, some to lose their relationships, some to lose their channels, some to lose their jobs. It's been a bloodbath out here. All right. And without a doubt, the state of Indiana was behind all of that. They fully supported it. Not just the state, but the family too. We even have allegations of some of these folks being paid to threaten us, dox us, harass us, intimidate us. It's been bad. These are criminals. Listen, these white nationalist fucks use the internet to function as a criminal syndicate in this day and age. Yes, they do. There's no question about it. I have it from the horse's mouth. They use the internet because everything's easier on the internet. And yes, I mean the Vinlanders. Yes, the outlaw Hammerskins. The Odinist. The corrupt correctional officers. The fingers of the cartel. And yes, I'm talking about the Sinaloa cartel out of Chicago, who's running the underground dope and human trade in Indiana. Yeah, have I been explicitly clear enough for you? Okay. In violation of the 6th and 14th Amendments, Mr. Allen was deprived of counsel at a safekeeping proceeding on November 3rd, 2022. This proceeding was a critical stage at which Mr. Allen was entitled to be represented by counsel and by himself so that he could object to this. All right. Also, there was a safekeeping proceeding that the inmate has a right to refuse if the reason is only for his own safety. And what it turns out is that Mr. Allen was provided an attorney by Mrs. Allen the day after his arrest. So the day of his arrest, Mrs. Allen started seeking counsel. The very next day, she put down $5,000 to retain counsel, who happened to be a Mr. Gibson. This Mr. Gibson contacted the sheriff and the prosecutor. Okay, do you got it? So the sheriff and the prosecutor were both very well aware that Mr. Allen had counsel, because counsel contacted personally the sheriff and the prosecutor. There was absolutely no question about it. There are receipts, literally. And what happened? Oh, well, it's multi-layered. It's multi-layered. Because here's what happened. Mr. Allen is charged with 2 counts of the murder for this crime. And it was felony murder by way of kidnapping. Okay. Judge Diener holds Mr. Allen's initial hearing. He's taken from Carroll County to White County Jail illegally without a safekeeping order authorizing this transfer. Okay. Well, On November 1st, he pens a letter requesting court-appointed counsel. There's a rule that says that the day you send the letter out is when the court has to take notice of that letter. So although the court decided not to take notice of this letter till November 9th, technically it should have taken notice and post-dated that for November 1st. So at this point, it should be noted that Mr. Allen should be considered to have dual representation, almost double lawyered, right? Mrs. Allen had provided him an attorney, Mr. Gibson, on October 27th. And then on November 1st, he requests state-appointed counsel. Now, Sheriff Lesenby transferred Allen to White County with no safekeeping order in place, which meant that by the time the safekeeping hearing did happen, Lesenby had no standing because Allen was then in the custody of White County Jail, where the White County Sheriff should have had the statutory authority to request any sort of safekeeping. All right. Now, this claims, additionally, that Judge Diener didn't have jurisdiction because Sheriff Lesenby had no standing with the order, okay, or the request. Now, on top of that, there's a second layer. It can only get worse from here, as I consistently say. There are two problems with Judge Diener in addition to all of this. Judge Diener participated or engaged in ex parte communications with the sheriff, helping him to draft the safekeeping request, which is a violation of the Judicial Code of Conduct, okay, Rule 310. Now, here's how it works. Lesenby wrote a failed safekeeping request, sent it to the judge. The judge then rewrites a safekeeping request, sends it back to the sheriff. The sheriff then sends that in as if it's his own for the judge to address. How does that sound? How does that sound for you? Diener, in violation of Rule 310, helped draft this safekeeping request. In violation of 2.9, engaged in substantive ex parte communications. So he was obligated at this point to recuse himself and request the appointment of a special judge before the safekeeping order was issued. Okay. But to show you how unhingedly corrupt these people are, let me show you this. I hope you're out there taking notes, because boy, you're going to love this one. Because this is how the shit happens. This is how they do it. This is good old boy 101. A northern Indiana judge has recused himself from the case of 2 slain teenage girls. An Indiana Supreme Court spokeswoman said Thursday. The Indiana Supreme Court is in the process of appointing Allen County Superior Court Judge Fran Gull as a special judge in the case after Carroll County Circuit Court Judge Benjamin Diener recused himself. A judge does not have to explain a reason for recusal. Diener's recusal came on the same day he approved a request from Carroll County Sheriff Tobe Lesenby to transfer Richard Allen, suspect in the 2017 killings of Abby and Libby. In order to transfer Allen, Diener wrote, "The finding is not predicated on any acts or alleged acts of the defendant since arrest, rather a toxic and harmful insistence on public information about the defendant in this case." The court found Allen to be in imminent danger of serious bodily injury or death, or represents a substantial threat to the safety of others. He also addressed what he termed a public bloodlust for information, calling it dangerous, saying all public servants working on the case do not feel safe or protected. The order went on to state the public's desire to learn about the case and access court records was inherently disruptive. As always, they blame the public for their inability to function under the rules of ethics and properly to protect the individual rights of every citizen of the state of Indiana. Oh no, they protect themselves. Now check it out. Let's take a look at this. Look at the date. I'm going to be nice and mean at the same time. Could all of you retards please look at the date? November 3rd. Listen to it. You know, we break shit down here. That's what we do. On November 2nd, pay attention to the dates. Tobe Lesenby, sheriff of Carroll County, filed a request by the sheriff of Carroll County to transfer inmate from Carroll County Jail to the custody of Indiana Department of Corrections for safekeeping. That's what we call the safekeeping request, y'all. Let's pause because Diener, I want to keep this PG-13, but I almost went rated R. Okay, listen. Did you see Diener in there say, the court authored a safekeeping request for Sheriff Tobe Lesenby, who then filed said request with same court or with said court? Did you see that? Or did you see some sort of representation if it was an independent action of Mr. Lesenby? On November 2nd, sheriff filed a request to transfer inmate from Carroll County Jail to the custody of Indiana DOC for safekeeping. Oh, it also seems kind of deceptive in saying from Carroll County Jail, not White County, right? The court, being duly advised, finds the defendant is an inmate awaiting trial and is in imminent danger of serious bodily injury or death, or represents a substantial threat to the safety of others. This finding is not predicated on any acts or alleged acts of the defendant since arrest, rather a toxic and harmful insistence on public information about defendant and this case. In general, this court has 30 days to rule on any motion that is filed by a party in any case. Yet, concurrent to the actual case naturally occurring, this judicial officer keeps getting direct requests from non-parties for public information, claiming that this officer has 7 days or 1 day when hand-delivered. And here in red, I put the gaslight for you, at least part one of the gaslight. While this officer is responsible for the entirety of the circuit court docket, it attempts to ignore the maelstrom of interest from the public. It is known that YouTube already hosts content regarding family members of this judicial officer, including photos. The public's bloodlust for information before it exists is extremely dangerous. Yeah, blame it on the public. All public servants administering this action do not feel safe and are not protected. You like how he put in bold or all caps, all public servants? Oh, you mean Sheriff Tobe Leazenby doesn't feel safe. Oh, Judge Diener does not feel safe. Oh, Sheriff of White County does not feel safe. Oh, Jerry Holman does not feel safe. Oh. But you're going to see an insistence. You're going to see a consistent theme throughout this entire Delphi murders conundrum, which is always shame, harass, blame, accuse, gaslight the public instead of take credibility accountability for your actions. But here down at the bottom, he says, when the public peddles misinformation with reckless abandon, we all are not safe. Wow, Diener. Wow. This is shameful. As far as the public's desire to learn about access to court records, remember, they've kept the public in the dark about the Delphi murders from day one. There was never transparency in this case. So actually the opposite. Just like during trial, the judge ensured there was zero transparency. To the extent that they even tried to fill up the line with troll farm, family-friendly, boot-licking, prosecution shill, public relations, douchebag, meth head, pedophile, drunk, retarded troll farm members, so that none of our people could get into that courtroom and come back and report accurately. Oh, yeah. These inquiries are inherently disruptive to the operation of the court. You see? So going back to this page 1 of this. Well, let's draw your attention to the date here. So ordered this 3rd day of November. Okay? And look again. First paragraph. On November 2nd, that was yesterday, day before this, Tobe Leazenby filed a request of the sheriff that you authored, Judge Diener. That you authored. So what you know what it seems like here? It seems like you authored the PCA. You helped with the PCA. You signed the PCA knowing it was full of misrepresentations and falsehoods and omitted pertinent information. So let's go back to that PCA. Muddy Bloody never happened. No, it didn't. Muddy Bloody never happened. Oh, what else was misrepresented? That Richard Allen is the person being described by all these witnesses who are describing a tall, muscular person dressed in all black. What else is being misrepresented? Oh, the time he placed himself there. Yeah. What else is omitted? Oh, the descriptions of the vehicle being a 1965 Mercury Comet looking vehicle that you're trying to turn into a contemporary Ford Focus. You omitted the fact that the description was a 1965 Comet. As a matter of fact, You misrepresented all those witness statements because you took all the witnesses describing another person other than Richard Allen, and you twisted that, misrepresented those witness statements. You took all the witnesses describing different vehicles, and you twisted those and misrepresented those as representing Mr. Richard Allen's vehicle, pardon. And then you omitted the fact that the 1965 comment was what was described. Okay. And you totally omitted the fact that Daniel Pearson, Shelby Hicks, Cheyenne Mills, and Shelby Duncan were all there. Should have never signed the PCA, but you signed it. Then you draft a safekeeping request for Tobe Lesenby. On November 2nd, he files the request you handed him in your court as if it was independent, and then you issue this order insinuating or implicating or even asserting that it is an independent request by Tobe Lesenby, but knowing damn well that you are the one who authored it. You sign the order citing the public bloodlust for information. And then you immediately recuse yourself. And who is set to replace you? Fran Gull, who allegedly already seen all the docs, says Richard Allen is guilty, 100% sure, wants harsh punishment to happen, wants him to be in Westville because that's where he belongs. I mean, you couldn't listen. If we were to make a movie about the good old boy bullshit in Carroll County, we couldn't make it any more perfect than what actually happened. And listen, like what am I getting back to? I'm getting back to the fact that this is how this case starts. This is where it begins. Okay. No, I guess I got to get back on the ball and not go on and on and on. But again, we're talking about the outright, blatant, in your face, dirty, fucking, downright scandalous violations of Rule 3.10 of judicial conduct and Rule 2.9. So he's deprived of counsel in violation of 6th and 14th Amendments. This proceeding was a critical stage. Why was it a critical stage? Well, damn, I'll tell you why. Because this is what set him up for a conviction. Remember when I said the point of putting him at Westville for a year was to force a plea deal, to put him in a pressure cooker where he would be threatened, stressed, abused, and his will would bend to enter that guilty plea. That was their fantasy, but it never happened. And as I've said a million times, but as a side effect, what they got were confessions because his mind broke. His mind literally broke in half. We've already proven that to you. It was April, May, June. Remember, I've told you, pay attention. April, May, June. Or really, March, April, May, June, July. April 2nd, April 3rd, while he's in the depths of his psychological break, he confesses after being fed information by a fangirl of the Delphi Murders podcast and YouTubes. Now remember the dates that are important here. October 27th, he has counsel. On November 1st, he requests court-appointed counsel. On November 2nd, Lesenby files the safekeeping request authored by Judge Diener. On November 3rd, Judge Diener issues that safekeeping order and then recuses himself. This says at the bottom, the safekeeping proceeding was plainly illegal from start to finish. First, Sheriff Lesenby transferred Mr. Allen to White County Jail on November 28 with no safekeeping order in place. Next, Lesenby had no standing to make a safekeeping request on November 3rd. Once Allen was in White County Jail, the White County Sheriff was the sheriff statutorily authorized to make a safekeeping request under Indiana Code 3533.11.1. Okay. Sheriff had no standing. Diener had no jurisdiction, but it happened anyway. Second, Allen had the right to have a judge other than Diener decide because Judge Diener engaged in the ex parte communications with Sheriff Lesenby, helping to draft the safekeeping request in violation of Rule 310 of the Code of Judicial Conduct. Rule 310 prohibits judges from drafting or reviewing documents. Look, read it, please, with me. Rule 310 prohibits judges from drafting or reviewing documents except for family members. Judge Diener also violated Rule 3.9 by engaging in substantive ex parte communications. That. All right, so listen, because you know what the idiots are going to say. No, that's not right. It's not illegal. It's not illegal. It's not in violation of Rules 310 and 29. No, it's not. No, it's not. Okay, so you're going to believe some trolls with barely a high school education and a whole lifetime of drug use and child molesting? Or are you going to believe all the attorneys who back up these attorneys who have drafted this? All right. Well, look, I'll stop here to address you, Miss Kathleen. I'll address you. Because the attorneys fucked up. As I've said, I've taken a lot of flack for this. I'm never going to kiss any ass of anyone in this case. I'm here only for those two girls. None of you, none of those attorneys, no one else on the YouTube. I'm here for those two girls. The attorneys fucked up big time. They fucked up in the middle, in the beginning, in the middle, and at the end. All right? They fucked up. Didn't you see how insanely mad I was when they rested early? And to be honest, I knew they were resting early days prior because I had been told. And I was insanely mad. When that person told me the days before why they were going to and when they were going to, I blew my top. And I cursed out everyone. I did. Ask Noe. I blew my top because I thought, how in the world are you going to rest when there's so much more? But I guess hindsight is 20/20 for these attorneys because they fucked around and they found out. And I'm sure that Andy Baldwin would agree with me. I've heard him say it himself in some of the interviews. He says, obviously we do something different. We lost. All right. It gets worse, though. As I say, it always gets worse. Down here at the bottom, Sheriff Lesenby's November 3rd request to transfer inmate was not served on anyone. There's no certificate of service attached. Indiana Code 3533.11.1 requires a safekeeping request to be made by motion. Indiana Trial Rules 5A2 and 3 required that Sheriff Lesenby's motion for a safekeeping order be served on the parties. Because Sheriff Lesenby knew that Mr. Gibson was representing Mr. Allen, he was required to serve Mr. Gibson with his motion for a safekeeping order. Where are we? If he claims he didn't know that Mr. Gibson was not representing, he still was required to serve Mr. Allen. Fourth, the safekeeping order or request was not verified. There was literally no evidence before Judge Diener from which he could make any factual finding required by Indiana Code 3533.11.1. Because a factual finding was required, with notice on parties, Sheriff Lesenby's safekeeping request was required. Sixth, Mr. Allen had a right to refuse. Okay? Now let's go back because we keep citing this 3533.11.1, right? Let's read this motherfucker. All right. Transfers for personal safety or safety of others. Can we all agree that, listen, can we all agree that this is the code which applies? I mean, I think that's a given. This is the code which applies, which is constantly referenced through these first 6 pages, which no attorney has disputed. Upon motion by the sheriff, prosecuting attorney, defendant, or his counsel, attorney general, or court, alleging that an inmate in a county jail awaiting trial is in danger of serious bodily injury or death, or represents a substantial threat to the safety of others. Let me stop. Remember that when we just read that safekeeping request or that order, that specifically it used this specific language that we see in this first sentence here. Okay, so the language they used are the language from the code, or is the language from the code. So you see this is obvious the correct code here. Alleging that an inmate in a county jail awaiting trial is in danger of serious bodily injury or death, or represents a substantial threat to the safety of others, the court shall determine whether the inmate is in imminent danger or serious bodily injury or death, or represents a substantial threat to the safety of others. If the court finds that an inmate is in danger of serious bodily injury or death, or represents a substantial threat to the safety of others, it shall order the sheriff to transfer the inmate to another county jail or to a facility of the DOC. designated by the commissioner of the department as suitable for the confinement of that prisoner and provided that space is available. For the purpose of this chapter, an inmate is not considered in danger of serious bodily injury or death due to an illness or other medical condition. Okay, so check it. He could have been transferred to any county jail. Did you just hear what the fuck I read? It shall order the Department of Correction. No, I'm sorry. It shall order the sheriff to transfer the inmate to another county jail or to the DOC. So he could have been transferred to another county jail, which would have been much better for him. I mean, as a matter of fact, he was, right? He was transferred over to White County. In violation of this code right here. But then they upped the ante and went ahead and transferred him over to the DOC, which probably they had an agreement. Look, can we be real here? Because, you know, we do conspiracies. We don't do bullshit. So don't you think that the commissioner of the Department of Correction received communication about this and that it was a collusion? Let's be real. I guarantee you, someone from Carroll County, whether it's Lesenby, Diener, McClellan, Gull, someone contacted the commissioner of the DOC and said, hey, we got this guy. Killed Libby and Abby. Can you put him in Westville? We need to put some pressure on him and get him to cooperate. I mean, let's not be delusional here. That's exactly what happened. One of these parties contacted the commissioner of the DOC and said, hey, we got to get this motherfucker in Westville or someplace akin to Westville where we're going to put a lot of fucking pressure on him and we can squeeze him and get him to plea. That's what happened. Okay, it wasn't left to his discretion. There was nothing by chance here. Nothing here happened by chance. Like I said, just like with Diener authoring this safekeeping request. Right? So nothing was left to chance. So when Lesenby contacted Diener, said we need to put him somewhere, Diener said, let me author that shit for you and give it to you. You give it back. And then we're going to have someone here is going to contact commissioner of the DOC and make sure he gets into Westville. I mean, let's be fucking real here. This shit ain't fantasy world. Right. And that's what Burkhart and Christine and Bob Mata and all these people can't say because they're practicing attorneys. They can't talk real talk. Okay. They have a code of ethics they have to stick with. That's why you come here for the swears. Okay. Now let's see. I'm trying to find page 7 here. No, 6. We're not done with 6. This whole thing has been a setup. Mr. Allen had no opportunity to exercise his right to refuse the transfer to the DOC or to make any objections set out above to the entire course of the proceeding. That's for quite a simple reason. Mr. Allen, either personally or through his lawyer, Mr. Gibson, had no notice of the legal skullduggery that would land him in solitary fucking confinement at Westville for 23 months pending trial between Westville and Cass County. Let me put your look. I've got a rant again. Let me put your ass in the hole for 23 days and see how you survive it. Question: who here has not been to jail? Because if you haven't been locked up like an animal, you don't know how the fuck it feels. Okay? 24 hours. Well, let's use the number 23 seems to be the number they're using. Okay? 23 hours, you'll fucking lose your mind. 23 days in the hole or in solitary, you'll lose your fucking mind. 23 months. Imagine. Just imagine. Finally, Mr. Allen's own absence from the safekeeping proceedings should be treated no differently from the absence of a lawyer to represent him. Once again, I'm sorry to keep jumping, but we got to go back to this one. Where was it? Top of page 3 is where it relates to this. Top of page 3, 353311(2). Right of inmate to refuse transfer. The inmate or receiving authority is entitled to a post-transfer hearing. The inmate may refuse transfer if the only issue is safety. All right. It's a violation of the Sixth Amendment to completely deprive a defendant of counsel at any critical stage. Let's look at the bottom here. The court need not speculate whether the safekeeping proceeding have serious consequences for an accused. In addition to being moved hours away from his lawyers for over 23 fucking months, Mr. Allen was unconstitutionally kept in solitary confinement in the Indiana DOC prison, shackled, leashed, hooded, and deprived of human contact. See Wolfish v. Bell, violation of due process for pretrial detainees to be kept in conditions amounting to punishment. As a consequence of that torture, Mr. Allen became psychotic. Short of his death, it's hard to imagine a more serious consequence for Mr. Allen following from the November 3rd safekeeping proceeding, which was a sham. So you see what I mean? Trampling the Constitution. Indiana is wiping their ass with the Constitution, is what they're doing. After a pig roast. Mr. Allen was not afforded the right to be heard by counsel or by himself at the safekeeping proceeding. This should be particularly disturbing because he had been given the opportunity, had he been given the opportunity to do so, he had an absolute right to refuse. Right? It's a violation of due process clause of the 14th Amendment that the Napui clause here, whatever that now here's let me pull this down a minute. The next right, the next one is tough. It's a constitutional violation for sure, but it's also a double-edged sword. Because not only is it a constitutional violation, it's also ineffective counsel. Okay, so it's a double whammy here. And this is something that Andrea Burkhardt also chimed in on, and I must say I'm in complete agreement with her. on that half, but I disagree on the first half as well in this way. She seems to not be so convinced that McClelland had knowledge of the fact that Weber was being deceptive, but I think that's bullshit. I think McClelland absolutely knew that Weber was not being. Well, let's be real here. There's a whole bunch of people have fucking been deceptive in this trial and in the lead up. Okay, you want to know who I think? The medical examiner. Why? Well, because it was only after about the second meeting with McClelland that he finally agreed to come up with this concept of a box cutter. Okay, that's deceptive. Weber, because they knew that there was something more with Weber, and they allowed that to go down. Sarah Carbaugh, why? Because she did not say for the first 2 years the word bloody once. After about the second meeting, third meeting, I think it was the third. I meant to have this pulled up for you. I don't have it pulled up. I apologize. But listen, we'll do a whole separate show on it. It was approximately the third time she met with them. Suddenly, she didn't say muddy not once and only said bloody. They knew she was full of shit. The whole timeline, the whole excluding of the third party perpetrators, exclude blah, 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 blah. You don't think that this prosecution and these state police knew this the whole time, that it was a bunch of bullshit and that there was deception going on? You think the family doesn't know it? Everybody knows it because it's plain as day. There's public open source information out here on the internet that proves. So even if they claim they don't know it, they have no good reason for knowing it because it's known out here in the real world. Everybody looked the other way. Everybody went with the program. They got with the program. Everybody colluded. Everybody went ahead and signed on to everybody got behind it. Kerry Timmons, Mike Patty, Becky Patty, Sarah Carbaugh, Jerry Holman, they all went with the program. And in the end, Doug Carter, the head of the Indiana State Police. And people say, oh, you realize how many people it would take, blah, 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 blah. Yeah, I do. Yeah, we do. Everybody did what they had to do to get that conviction. Now on Brad Weber, you think they didn't know Brad Weber's story was bullshit? Let's be real here. Everybody's known Brad Weber's story was bullshit. I'm just going to skip it. I'm going to skip the whole fucking section. See, since this Brad Weber thing, I've sort of come with a new, it's sort of like I've had a new revelation. Question. Remember the theory going back ages that someone was in a vehicle waiting for those girls and kidnapped those girls off the south end of that bridge? Do you think it's possible? Let's see. Then we go to more skullduggery, right? So we know Brad Weber. The point being, for all of you who don't know Brad Weber, the point being that he lied on the stand. The state knowingly allowed him to lie on the stand. Okay? And what the argument here is that it's a 14th Amendment violation, due process, is then that's Napoli v. Illinois, in which the state presented testimony they knew was false. Okay? It's highly likely that Brad Weber, all right, let me just fucking go ahead and say it. Remember we just went over the Keegan Kline in the cemetery? And I read a statement, I believe it was from Old Hart, who said, anyone familiar with the area would know that if you parked in the cemetery, you could easily access the north end of the bridge. I wonder, I really do wonder, you know, that phone stopped moving at 2:32? Think about it. Let's say at, I don't know, 2:28, they are intersected at the north end of the bridge. They go down that trail. They go to the crime scene. And by 2:32, one of the girls drops the phone. Then someone ushers the girls on up to the cemetery. They're put in the vehicle. That vehicle, by a later time, is captured on camera. We'll get to it later. Fuck it. I don't want to talk about it. Now, next one. Ron Logan. Now, you know I'm not a fan of this. Okay. You know I don't think Ron Logan killed the girls. I'll never believe it. I don't fucking care. I don't think it happened. I think it's all bullshit. Jailhouse confessions. If you're ignoring Richard Allen's jailhouse confessions by a third party, why in the hell would you choose to selectively accept Ron Logan's jailhouse confessions by a third party? It's ridiculous. Okay? I don't believe Ron Logan's jailhouse confessions by a third party because it would be hypocritical. But here's what's the bomb in this one. Let's get to it. Is that it? Oh, come on, Prof. No, it's the previous. Box cutter. Look at the bottom. It's right here where I'm pointing, actually. Pulled box cutter out, slit oldest one, hit an artery. Dude, this is May 15th, 2017. June, actually okay, back it up. The original tip was May 15th. This particular interview was June 21st, 2017. These are some handwritten notes by the officer who did the interview on June 21st. But what's the whole point of this? Box cutter. The whole point of this is box cutter. Now, what it tells me, Ron Logan had knowledge of what happened. Absolutely. Possibly he was involved. Possibly he witnessed it. Possibly one of the little ne'er-do-wells that he allowed to malinger around his property told him. In whatever way, Ron Logan had knowledge he was a part of it, one or the other. But you got Ron Logan or Mr. Davis, someone talking about a box cutter in June of 2017. Now, put that together with the fact that I said the medical examiner did not mention or speculate or have a revelation about a box cutter until the second or third meeting with McClellan. Remember that? Please put it in the chat if you remember, because if you don't, we have to be in agreement. We have to come to an agreement right now that you either remember that or you don't. And like I said, I meant to have the receipts for you. I didn't have time before the show to get all of those. But it's known that the medical examiner did not come up with the concept of a box cutter until shortly before trial, after the second or third meeting with McClellan. I'm waiting on the chat to tell me that they saw that or have heard that or can verify that. Okay. Judge Jessica says she remembers it, so I'm good with that. I want to know where. Let's find it. Let's find it in the documents, Jessica. But here's the thing. It was his third, after his second, I believe, at a minimum, but second or third report or meeting with McClellan or the prosecution that he suddenly had this revelation that there's a box cutter. Okay. Now, put that together with the concept that in 2017, a box cutter was being talked about with Reese Davis and the officer and in the Orion tip. So a box cutter was a thing in 2017 in June. Which means Monica Walla could have had knowledge of a box cutter. Well, I mean, shit. The troll farm had knowledge of a box cutter before trial. You know how we know? Because they were on their fucking channels talking about it. It was the whole thing with those two. The whole thing. Box cutter, box cutter, box cutter, box cutter, box cutter, box cutter, box cutter. If the troll farm was talking about it on their fucking live streams, if Monica Walla was treating Richard Allen watching those live streams in the Discord with these fuckers, how does a box cutter become suddenly something only the killer would know? I mean, that means from 2017, that means from June 2017 and anything after, it was no longer something only the killer would know, because anyone would know about a box cutter because there was chatter out there. Like I said, same thing with the van, the concept of a van, the whole deal with the fucking van. Same thing. You had Monica Walla watching all the podcasts and all the fucking Reddits. There's mentions upon mentions upon mentions of vans. So both box cutter and van are nothing whatsoever. It's not something only the killer would know. Shit, even the concept of sticks. I just showed you Sonny Justice talking about sticks. What? It was fucking 3 years ago. You guys want to see that? Should I have that ready to put in your face somewhere if I need to? Shit. I don't have to. We just talked about it in the prior show on Anthony Schatz. I read for you the quotes from the Sonny Justice program in which she was talking about those who lived very close to Kig and Klein. And within that segment, she was mentioning the sticks on the bodies. So let's see. So box cutters, not anything only the killer would know. A van is not anything only the killer would know. I told you before, in the helicopter footage itself, which is posted down here on this channel, you can see the van in the driveway at Weber's. So you had the van from the very beginning was talked about. Box cutter from the very beginning was talked about. Sticks on the bodies, and actually, the term I was told was satanic symbols on the bodies, talked about from the very beginning. So at this point, what is something only the killer would know? Shit, I would say hardly nothing. I would say maybe painting the F on the tree, maybe any particulars of the details of messaging with the girls, because we know that Anthony Schott's accounts were messaging the girls' accounts. Remember yesterday, another thing I showed you in the Anthony Schott show was that both girls were communicating with the Anthony Schott's accounts. So there's more than one Anthony Schott's accounts. You got both Abby and Libby communicating with the Anthony Schott's accounts. So I would say pretty much the only thing it seems that only the killer would know is what the content of those messages were. Anyway, geez, man, this is such a headache. And they convicted this guy. Remember, first it was what, 9-3, right? First it was 9-3. And then shit got real, and then it was 8-4, 4 holdouts. And then what happened? They looked at that fucking fraudulent bridge guy enhancement, and then decided that they agreed. Then they were able to convince all the holdouts to agree with unhinged Brian Harshman, which I've also done a deep dive on. So if you're interested in what the effect of Brian Harshman was, go ahead and watch that one. That's not true, Jay. It's not true. It's not true, because well before this trial, just about the time of Richard Allen's arrest, I was told the details of the injuries to the girls. All right, let me fucking be real with you on this one. Because see, Jay, I can't let you believe stupid shit. That's stupid to believe that. Let me put it this way. In the same month that Richard Allen was arrested, I would say this was late October or early November, immediately when he was arrested, one of my people who is in this live chat right now, she's in this live chat right now. She told me about the crime scene. And she said, Prof, blah, 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 Libby's throat. Okay. And I said, well, what about Abby? And she said, Abby had a stab in the artery or whatever right here, a clean stab in and out. Now, tell me, how is that something only the killer would know when we had locals discussing it before Richard Allen's arrest? So even that is something not only the killer would know. Trust me. Listen, David Erskine took photos of those bodies and he ran around telling everyone about these bodies. I'll tell it to you that way, Jay. There was talk. The reason there was talk is all these people were talking in Delphi. The searchers were talking about the bodies. There was nothing only the killer would know. Okay, because they were fucking talking. They were talking about the symbols on the bodies. They were talking about that one was dressed and one was not. They were talking about the injuries to Libby being almost taking her head off, and the injury to Abby being only the stab in the side of the neck. They were talking about Abby was posed like an angel. That was the term used for me, like an angel in a casket. I was told that she was posed and laid out very respectfully as if she was in a casket. This is before we even saw the PCA. I was told Libby was disrespected. Abby was placed like a little angel in a casket. So I'm telling you, everything that I was told about this crime scene turned out to be true 2 years ago. So that's what sucks for everyone. That if you had not been talking to locals and you don't know all the details, you might think things like that there's things only the killer would know. There's nothing in there, like I told you about these Ron Logan confessions. It's bullshit to me. It's all bullshit. It sounds like to me, yeah, he knew what happened. Oh yeah, but it's not. It's not that doesn't mean he's the killer. There were things that he said that only the killer would know. It means that he knew about it. And it would make sense that he would know about it. I mean, dude, he was harboring Brad Holder, Garrett Kurtz, you know. I mean, dude, uh, Tony Klein, Brad Holder, Garrett Kurtz. Think about who were regularly hanging out on Ron Logan's property, cooking meth, smoking meth, and running around and hunting and running the four wheelers and camping and Noe is just always so hilarious because Noe said it like this. He said, "Ron, Prof, the thing I blame Ron Logan for is maintaining a common nuisance, which is I believe is a charge. It's a law in Carroll County. It's just a term Noe likes. He says Ron Logan is guilty of maintaining a common nuisance. So if he was maintaining those common nuisances and they were talking, he would immediately have knowledge of what happened because those were all his fucking buddies. Like I'll say it like this: I think the people who killed those girls were Ron Logan's buddies, Garrett Kurtz, and all of these others, and all of these in the Frank's memorandum. And that's my thoughts. Anyway, so I think there's nothing to there's like I said, if you're going to accept these Ron Logan confessions and you don't accept the Richard Allen confessions, it's sort of hypocritical or it's a conflict, and I don't accept any of them. All of this information has been out, but I guess to quickly get through this and get to my point. My point about it is that the concept of a box cutter is interesting. Okay, end of the deal, and that was known as far as this is. The interview is June. Is it June 12th, June 21st, 2017. So we're done with it. Okay, now let's get to the good stuff. December 3rd. I mean, what am I thinking about December for? All right, number 3, not December 3. Defendants Exhibit 5, affidavit of Stacy Eldridge, states dirt or water damage to the phone could not have caused the auxiliary jack. Okay, now this blows up. This blows up the timeline. Well, let's pull it up. I'll just skip over this in here. Now here we go. Stacy Eldridge. By the way, um, I don't know if you guys saw, some of you may have missed, but Rick Snay aired an interview with Miss Eldridge today, and it was really good, and she's really good. And so, for all of you who did not see that, like I said, Rick Snay's channel, we're probably going to deep dive it, but Rick Snay had a video interview with Miss Eldridge here. If you're interested in this part of it, this piece, um, listen, I'll put it this way. I'll put it before we get into this. The reason I'm so resistant to blaming Ron Logan is you really got to think, dude. The FBI turned his ass inside out, literally. I mean, I don't know about you, but I have faith in what the FBI did. Okay. The FBI went in there, turned the place inside out, came back with nothing. Now, if you think that there was evidence that Ron Logan murdered those girls, don't you think the FBI would have found it and done something about it? This was before, remember, this is before they're kicked off. It's why Ron Logan doesn't matter to me, because I liked Nicole Robertson. Remember, Nicole Robinson, we went in the early days on this channel, we went in depth through the Ron Logan warrant application. All right, it's very interesting, actually. And we probably should go back through it because there's a lot of interesting data points in that from Nicole Robertson. But basically, that they turned that place inside out. They did not produce any evidence to make probable cause and convict or even charge. And so I look at this Ron Logan and thought he was talking shit. And maybe this other guy's talking shit. Reese Davis was also talking shit. And there's a whole bunch of shit talking or whatever. But people, this whole community, Delphi, that's why I always shame Delphi. And I say, look, shame on you, Delphi. Shame on Delphi. Ron Logan's search warrant was March 2017. And remember, they had him incarcerated for how many years? You don't think that they put Ron Logan in jail because they thought they would be able to get probable cause, arrest him for Delphi murders? And they just weren't able to. It was a nothing burger. It was a nothing burger. So Ron Logan, yeah, I think he knew what happened. And I think he knew he wasn't guilty. So he knew he could talk shit and he could talk as much shit as they want. They would never have evidence on him. No, I don't believe it. I don't believe it. Say what you want. I don't believe it. Do you think the FBI would protect Ron Logan? Come on, man. I don't know why I always have to fucking argue for Ron Logan like I like him. I don't like Ron Logan. I'm saying, like, I think it's ridiculous to think that Ron Logan killed those girls, because how do you explain all the other shit for 7 years that has surfaced in this community? You can't. You cannot at all address the Dropbox. You can't address the you can't address the snuff film allegations. You can't address the entire Johnny Messer and all this other shit from the Franks memorandum. You can't address any of this shit if you make Ron Logan a lone wolf killer. It's stupid. It's just as stupid as Richard Allen being a lone wolf killer. It's stupid. And if the FBI couldn't do it, you're not going to do it by talking shit on the internet. All right, so Eldridge. How do you explain Chris Mathis and Garrett Kurtz talking with intimate knowledge about the Delphi murders as if they were involved if Ron Logan killed the girls? How do you explain Ashley Garth, Nick Edwards, and Sheena Cottrell talking about a snuff film if Ron Logan killed the girls' lone wolf? How do you explain Keegan Kline talking about Tony Klein and some other third party killing the girls if it was Ron Logan? It's a lone wolf. How do you explain the entire Frank's memorandum and all the fucking footnotes if it's Ron Logan, lone wolf killing the girls? How do you explain the Kokomo crew and the fucking Odinist if it's and the methamphetamine if it's Ron Logan killing the girls? Come on. It makes a whole lot of sense the other way around. All those people were people he harbored. Okay? If he was harboring a bunch of dumbass criminal meth heads and they killed the girls and he knew about it and he went dispose of evidence by going make that dump trip and making an alibi and trying to keep, like, if it was Ron Logan, why the fuck would he kill those girls on his own land and leave them there? Wouldn't he burn them? Wouldn't he throw them in the creek? Come on. Logic doesn't add with Ron Logan killing the girls. Now, covering for it, lying about it, harboring the criminals who did kill him, participating in some way. Yes. You know, it almost seems like it's a decisive move. Remember I said there's controlled opposition in this community. And if you think there's not, you're retarded. There's controlled opposition. And it feels to me like the whole deal right now was to insert Ron Logan as a killer of these girls to continue to protect the guilty parties. Okay, so remember, I said from the very beginning, the intent was to set up Ron Logan, I thought, in the very beginning. To put those bodies on his land, make him guilty. He's bridge guy, or he looks like bridge guy. Okay, so I guess the whole fucking show's about to be about Ron Logan. It's supposed to be about trampling Richard Allen's rights. I think the point is you're setting up Ron Logan. It didn't work out because he died, and the FBI wouldn't do anything. So then you set up Richard Allen, okay? And now that for whatever reason, controlled opposition is trying to set back up Ron Logan again. It's like, look, it's not fucking Richard Allen. It's not Ron Logan. Now, could either one of them be involved? I guess. It's got to be more than that. Lone wolf killer is a stupid idea. When you look at what was done with these bodies, what was done at that crime scene, how those bodies exhibit zero defensive wounds. It's absolutely improbable, inconceivable, unlikely that there was a lone wolf killer of these two girls. Now, what do you think? Richard Allen and Ron Logan? Come on, man. I guarantee you, people are being protected, and it ain't Ron Logan being protected. Bachelors, masters from Bellevue. Digital forensics. Adjunct professor, Oklahoma State University Institute of Technology. Adjunct professor Bellevue, teaching cybersecurity and digital forensics. Director of cybersecurity, Lincoln Electric System. Senior staff cyber investigator program manager at GE from 2012 to 2017. FBI from 2003 to 2012, digital evidence instructor and computer analysis response team senior forensic examiner. This is a heavyweight. Okay, she's a heavyweight. Trust me. Whose word are you going to take? Whose word are you going to take? Uh, defense industry and FBI, cyber investigator, computer analysis, digital evidence, senior forensics examiner with multiple degrees? Or are you going to take an ISP officer who had to go out in the fucking hall and Google something? Okay. On top of that, she's got all these certifications, right? You see them. You see them. Multiple FBI and Celebrite certifications. Okay. Do you think Cicero or Cecil know anything about this shit? All right. This is the actual expert. Data from Liberty's phone shows iPhone 6S showed wired headphones plugged in at 5:44 p.m. Unplugged 10:32 p.m. All of this was brought up in trial. You know, I don't know. This is another thing that's confusing me, and maybe one of the attorneys could chime in. Shit, I wish they were fucking watching now and would chime in the chat. Why is this? How is this newly discovered evidence? All of this was mentioned in trial. How is this newly discovered? I'm just trying to understand what's newly discovered about this. Is this more the case that once again you dropped the ball because you did not argue this fervently enough? This is the timeline nuclear bomb, and you just let it fly by. I just can't understand the decisions of this defense team. All right. iPhone 6Ss were equipped with sensors to indicate water damage. There's no indication in the data that indicated sensor identified water damage. I would expect to find evidence of water damage notification that is displayed to the user to be present on the phone. I reviewed the Celebrite Logical Extraction Report, February 15, 2017, by Brian Bunner. Celebrite Model 1 to 3 Extraction Report by Brian Bunner, October 12, 2017. Digital Forensics Examination Initial Report by Cecil on August 21st, 2019. Digital Forensics Examination Supplemental Report by Cecil, August 18, 2024. None of the above reports or extractions contain evidence of dirt or water damage to Liberty's phone, nor do they indicate that it was particularly dirty or covered in debris. See, that's where we're not emphasizing enough the facts here. She's looking at 2 Celebrite extractions by Indiana State Police, 2 digital forensics reports by Mr. Cecil, Indiana State Police. All 4 of these reports, and neither of them, none of them, out of 4 reports, 0 indication of water damage. Okay? None of them show dirt or water damage. 4 forensics reports. Now, you're countering that with one Google search from a supposed forum that says somebody had water damage and it showed that there was a headphone plugged in. I mean, there's no comparison. And this is where it gets insane. This is where reality is insane. You see, you know how I say that the gaslighting is extreme, it's unhinged, it's off the charts. Okay, when it came down to this trial, they lied to the jury. They kept information from the jury. Remember when I made the analogy of being blind? Okay, this jury was blindfolded to the truth about the Delphi murders and about the murders of these girls and all of these data points and the timeline. The attorneys were blinded to the truth about the Delphi murders. You know why? A, they ignored social media. They've now admitted that fact. They ignored the work of hundreds to thousands of people over 7 years. Okay. Do you understand how many million man hours that is that these attorneys ignored? Because they didn't have time. They didn't have anyone specially suited to do the task. They were forced to have information volunteered to them, which they were overwhelmed with. Okay, that's point A. Point B, the discovery was handed over to them in a combative manner. How, Prof? I'll tell you how. Kathy Skank and Steve Mullen intentionally confused the discovery among the 27 terabytes or whatever it was. The information was scattered like confetti. The defense investigators I've spoken to said, Prof, it was as if these thousands of documents were just thrown up into the air and they just fell out like confetti. And that's what was handed over to the defense, spread among how many hard drives? 24 hard drives or something? Nothing labeled properly, nothing sequentially properly, nothing in a timeline. Absolute chaos in the manner in which discovery was handed. And keep in mind, we've taught you before and shown to you that this discovery, not only was it disorganized intentionally the way it was handed over, overwhelming amount of data, but it was also handed over anywhere from 3 to 12 months late. Remember how many times discovery was denied? Remember, we're not even talking about the 70 days that's just outright deleted and a Marathon gas station. Okay, all of the deleted shit. Oh, and not to mention Liberty's phone, which had information deleted by the sister, right? We're not even talking about all that. We're talking about just discovery. There was discovery that was hidden. Oh, yeah, we don't know who Mr. What's his name? Jeffrey Turco. We don't know who Professor Jeffrey Turco is. We just don't know. We don't know if we'll ever be able to find Jeffrey Turco. Sorry. Oh yeah, we don't know who did the geofencing. Oh, sorry, we don't know who did it. We don't know Kevin Horan at the FBI. No, we don't know the geofencing. Oh yeah, you figured it out? Okay, shit, yeah, I guess we do. So this defense was operating blindfolded, kept ignorant, partially through the fault of the state being obstructing in the way that the defense was handed over. And keep in mind, this prosecutor made sure that no mention could be made of that. Do you remember that filing? Where he made the filing saying, you can't even mention the manner. We're going to look at it momentarily. And the jury was kept blindfolded and ignorant. Okay. What am I getting at? The conclusion. I want to get to the conclusion of this. So let's see. Especially important here, number 16 and on down, listen. None of the above reports contain evidence of dirt or water damage, nor do they indicate that the phone was dirty or covered in debris. I reviewed photos of Liberty's phone. The phone does not appear to be wet or dirty or covered in debris. No pictures were taken displaying a message indicating liquid had been detected. No pictures were taken of the control center of the iPhone to document the headphones were being reported as plugged in when they were not. I reviewed chain of custody. It did not document that it was received in a wet or dirty, damaged condition upon receipt. A real big one right here, number 18. iPhones that have recent water damage are known to reboot spontaneously, requiring multiple attempts to complete the extraction with a forensic tool. No instances of this were documented or reported by the Indiana State Police. 19. I'm currently unaware of any scientific or technological research suggesting that water or dirt damage to an iPhone 6S would cause the phone to inaccurately log wired headphones or wired headphones out. Okay, so are you getting the gist of this now? The point of it is, you've got a very extremely well credentialed digital forensics expert here with all of these points. And that's being argued by an Indiana State Police who went and did a Google search out in the hallway that allegedly pulled something from a forum that alleged that there was a water or dirt damage that caused that. I mean, there's no comparison. There's absolutely no comparison. And how that was allowed to fly in court, I just don't understand. I really don't. It's the same that I don't understand how Mr. Brian Harshman's willy-nilly, a wild speculation that the voice of the enhanced bridge guy in somehow it's Richard Allen. Remember, when no one in the entire court, no one of the witnesses, no one at all whatsoever could point at Richard Allen and say, he's the guy out there, blah, 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 blah. He's the guy meant to portray in the sketches, blah, 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 blah. The video doesn't show that it's him. Nothing shows it's him. There's no forensics that shows it's him. There's no DNA that shows it's him. There's no blood in his car. There's no blood on his clothes. There's nothing that shows that it's him. But Brian Harshman saying, it's him. That voice is him. But that was allowed to fly. Same way, Brian Harshman was allowed to claim that there's 60 plus confessions when all that was exhibited were 3 or 4 at best, 3 or 4 confessions at the height of his psychotic breakdown. It's absolutely unbelievable. If you don't think this man's rights were trampled and that it could happen to you, you're smoking that crack rock. Now I wanted to move on to some more unbelievable facts about this case. Just absolutely unbelievable here. You may remember this from April 29th. Okay? April 29th. Just a moment, please. All right. Time for some water. The throat's starting to go. Thank you for everyone who sent a super chat or bought a membership, everyone supporting the channel, and also those hitting the thumbs up, joining the live chat. Thank you for supporting the channel. Appreciate it. Motion in limine. April 29. This is an absolutely unbelievable document. And it gets worse too. Here, McClellan is requesting the court order the defendant and the attorneys to refrain from the mentioning of one, any comment about counsel for the state that constitutes a personal attack, which means he didn't want you to talk about Luttrell. Okay, he didn't want you to talk about Luttrell. Any comment which constitutes the personal opinion of defense counsel about any evidence. For instance, defense counsel cannot vouch for the truthfulness or competency of any state's witness, including police officers or any of his own witnesses. Right, you can't. So he didn't want to hear any characterization. All right. 3, any innuendo or inference that is not supported by admissible evidence. He didn't want any mention of these particulars of some sort of criminal element possibly murdering these girls. Nope. Any attempt to indoctrinate the jury. What the hell does that even mean? What does that even mean? I'd like to understand what is meant by number 4. Attorneys who watch the channel, please leave me a comment. What the hell do they mean? What does that even mean? Indoctrinate the jury. What do you mean? Because you know, McClellan, I think you indoctrinated the jury. The way that at the end you fantasized about the victims, trying to turn them into heroes, coming up with a complete fantasy world story or scenario where the one girl videos the bridge guy intentionally because she's a sleuth, or the other one where you come up with this wild imaginative scenario where Abby in her dying moments takes the phone and hides it under a shoe under her own body to try to hide it from Richard Allen. Or possibly the way that you put up all kind of gory fucking crime scene photos to emotionally traumatize the jury in your closing statement. I think that was indoctrination, and it was absolutely disgusting. I've never seen anything more disgusting from a prosecutor, honestly. It was emotionally, narcissistically abusive and manipulative, and it traumatized the jury, and that was the only way you could achieve your ends, I guess. Any attempts to have the jury prejudge the credibility of it? Well, what about Sarah Carbaugh? Yeah, it would have been nice, right? It would have been nice if they could have said, "Hey guys, Sarah Carbaugh's full of shit. Don't listen to her because, she never said bloody until about the 3rd interview she had in 2019, when all of a sudden she radically changed her story." Any hypothetical questions that includes facts that are not in evidence or questions that are not helpful. Wait, did you just say facts? Facts. Any hypothetical questions that includes facts. Yeah. Like I said, you had to keep the jury blindfolded and ignorant of the facts for them to convict Richard Allen. And that's justice in the American criminal justice system. Any attempt to introduce evidence of third-party motive. Wow. Look at this. Look at this. Down at the bottom. Odinism, which if our attorneys were a little bit better, they would have called white nationalism, okay? Or a gang. They would have called a gang with white nationalist, Nordic, or Norse pagan-like beliefs. Okay? The Odinism was a mistake, and I think that Baldwin knows it. That was a gang of white supremacists, dope-dealing idiots who also collude with corrections officers. There's really a thin line between the two. Nothing about cult or ritualistic killing. Oh, although the scene was staged to look like a ritualistic killing. Okay, interesting. So the crime scene absolutely looked exactly like a cult or ritualistic killing looks. Do you guys remember Dr. Dawn Perlmutter? I believe we did a whole show on her. She explicitly went through the crime scene and how compelling it was in terms of its signatures of occult or ritualistic killing. And actually, I'm going to read that for you. Oh, and here's where it gets rich. Look at this motley crew of ragtags. Okay, who all happen to be friends of Ron Logan who hung out at Ron Logan's. Oddly enough, right? Right. Those who frequented the crime scene, oddly enough, Brad Holder, Patrick Westphal, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Kline, Jerry Klein, Ron Logan. Ah, how odd. The very crew that is known to have frequented Ron Logan's property. Any reference to an investigation by Todd Click, including reports or investigative materials from Todd Click, who we subsequently set up and arrested. Yeah, interesting. Oh, this one's rich. Any reference to geofencing? Wow. Geofencing. So geofencing, you mean the 3 phones that are lingering around the crime scene and one which literally leaves the crime scene within 3 minutes of that phone headphone jack being activated. So 5:44, I believe it is, the headphone jack's activated. Minutes later, that third phone skedaddles, leaves the geofencing. Oh, we can't talk about geofencing though. Geofencing. Wow. Number 10, reference to prior bad acts or acts of any witness. Really? Would that not be relevant to the credibility of the witness? Oh, and this is rich. The number 11 here. This is what I was saying. This is what I was telling you. Any reference to how the files were labeled that were handed over to the defense as part of information and discovery provided to defense by the state. Really? So you mean no mentioning how Kathy Shank and Steve Mullen completely scrambled 26 or whatever it was terabytes of information, thousands upon thousands of files, completely scrambled, confused, thrown up like confetti, so that it would be an impossible task, monumental undertaking to try to organize, which proves bad faith on the side of the prosecution. You don't want the jury to know the bad behavior that your people have done from the very beginning. Like I said, Tony Liggett misrepresented witness statements. He omitted information. Judge Diener signed documents he should not have, which is why he recused himself and he blamed it on bloodlust. Indiana State Police or the Unified Command, whoever you want to blame it on, Carroll County sheriffs, they deleted 70 fucking days of interviews, many of which included the primary third-party suspects and family. Oh, on top of that, let's talk about the family's cell phone extractions that were never performed, or if they were deleted or hidden and never handed over, that would confirm all of the family members' stories, their whereabouts, their timelines, etc. Wow, it's just unbelievable. It's unfathomable, inconceivable how this was allowed. Any reference to PowerPoints made by the state. In other words, law enforcement product. No law enforcement product. No Todd Click, no Kevin Murphy, no Greg Ferenczi, no Unified Command PowerPoints, nothing, no ISP, no Delphi Police Department, no FBI, no PowerPoints, but no fucking law enforcement product at all. Thank you, Jake. Thank you, Jake, for the 20 memberships to the viewers. That's incredible. Guys, you should know that's a huge gift to the channel and a huge gift to you. And I'm so glad that there's members. Members, if you just got a membership, when the show's over or tomorrow, go watch Train Guy. Train Guy. Wow, Jake. Thank you. All right, that's the motion in limine, okay? Now, they clap back. They clap back. This is April 30th. Comes now. The defense daddies. And they say, on April 28th, the court directed an email to the state and defense addressing various legal and logistical matters associated with forthcoming jury trial. Second to last paragraph, the court, without any prompting by lawyers from either side, including the following statement. I am quite familiar. This is the bitch. Okay, let's be real here. This is the horrible attitude of your judge who had already decided Rick Allen was guilty. I am quite familiar with the law regarding third-party perpetrators, and unless the defense can provide a nexus between any alleged third-party perpetrators and the charged crimes, those allegations are unsupported and will be inadmissible. Guarantee you. Like I said, how do you keep the jury ignorant? On April 29th, the state, without fucking hesitation, accepted the court's invitation to limit evidence. Paragraph 7 of the state's motion in limine, that's what we just read, is proof of that. So you see, she opened the door. Like I said, she's changed every diaper of McClelland, breastfed him every single meal, burped him, wiped his little butt, put him to bed. Made the path easy, fixed him his meals. She laid the way for McClelland. And number 3, they drop a fucking bomb here. The court has established a pattern of summarily denying pretrial evidentiary motions filed by the defense throughout this case. That's called bias for your retards in the back. That's called bias. Okay? It's called bias. What they're doing here for the appeals court. Okay? The court has established a pattern of summarily denying pretrial evidentiary motions filed by the defense throughout this case. You know what they left out? And sustaining the prosecutor's objections at every single fucking turn. Object, 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 object. Sustain, 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 sustain. They left that one out. The motions have been denied despite the defense supporting many of its motions with evidentiary support in the form of video interviews, audio interviews, crime scene photos, affidavits of witnesses, and various other forms of corroborating documentation. In contrast, the state's motion in limine contains zero fucking supporting documents or other information justifying limitations. You got it? You get what they're saying in this paragraph 3? It's basically it's laying out the whole case that she's biased. She's denied every evidentiary motion by the defense, and going ahead and greenlit every single motion by the state, despite no supporting evidence. It's clear bias. The judge has exhibited bias since day one. And look, keep in mind this that I put in your face at the beginning of the show. Judge's assistant has seen all the docs. She says Richard Allen is guilty of sin. She's 100% sure, wants harsh punishment. She said how she hopes the judge will keep him in Westville because that's where he belongs. Remember, this was a long time ago. I'll get you the date. All I have to do is ask the guy who sent me this. Sure, she's not biased, sure. Defendant Allen's defense team is quite familiar with the law. This is a little snark. Okay, they're hitting back with some snark. Yeah, bitch, we're familiar with the law. That's their way of saying it with ethics. We are quite familiar with the law regarding the admissibility of evidence of third-party perpetrators. Yeah, you would think so because they've been lawyers for how many years? Their entire careers? All right, exactly. The law requires only that defendant Allen establish, quote, some connection between third-party perpetrators and the crime. No, I don't know. I would say the body's being found on Ron Logan's property. That's a nexus, isn't it? I mean, it's in his yard. Let's see. Bodies found in my backyard. That's not enough of a nexus to mention me in a trial. And that's just Ron Logan. There's all the others too. Defense has spent the better part of a year conducting discovery, seeking out exculpatory evidence from the state, and developing credible defense-related theories, which the defense intends to present to the jury in this case. The state of Indiana has sought out no assistance from the court in an attempt to limit the discovery process. In fact, the defense has conducted numerous depositions involving third-party perpetrators without the state seeking any orders of protection or orders limiting the discovery process. You know what that's saying? Okay, let's break that one down. That's paragraph number 5. It's basically saying you knew this whole fucking time where we were going with this, and you waited until the last minute to try to trip us up and to make sure that we wasted all of our time. And that's occurred more than once in this case. Okay, that seems to be part of the MO of a fucking corrupt prosecutor here and the prosecution here. Their MO is they delay to wait in the last minute to do the switcheroony. Okay, to mislead, delay, obstruct, and trip up the defense. They've done it multiple times. Delay, trip up, mislead, lie. And that's justice. That's constitutional rights. That's what Lady Justice is supposed to be for the American people. It's kind of militant, right? It's like, by any means necessary. You know, that's what I got from that Jody Williams, right? He's guilty as fuck, and we know, so by any means necessary, he's going to burn. That's what they did. That's what Judge Gull, Nick McClellan, Unified Command, Indiana State Police, Doug fucking Carter, and the families have done to Richard Allen. Militant Vigilante justice in this way is not American justice. It's not supposed to be this way. The defense anticipates that its trial presentation will include somewhere between 1 to 2 dozen witnesses that will provide relevant and credible information for the jury regarding the culpability of third-party perpetrators. Yeah, right. Yeah, right. That was a fantasy. Was not allowed. To the extent the court carries out its warning referenced in the April 28th email, the trial will be reduced to unnecessary delays due to lengthy offers of proof and lengthy delays due to large gaps in the scheduling of witnesses to appear for trial testimony. The absence of any articulated and reasoned legal guidance from the court in advance of the trial would promote lack of judicial economy throughout the proceedings. Wow, whoever this is knows how to fucking speak or write. The defense requests the court set the state's motion in limine for hearing for a full day during the week beginning May 6th, at which time parties would be entitled to present evidence regarding admissibility of third-party perpetrator evidence. This approach to the business of jurisprudence would assist in clarifying the nature and scope of the evidence to be admitted at trial, which would benefit both parties, the court and the jury. Okay. In its motion in limine, the state requested to limit evidence regarding several other matters. State paragraph 1. State requests relief from any comments about counsel for the state that constitutes a personal attack on the attorney for the state or comments about the role of the state's attorney. Said request is unsupported by any specific facts. Right. No, here's the facts. We don't want you to talk bad about Luttrell. States paragraph 2. Limit the defense from comments which constitute personal opinion of defense about any evidence, witness, outcome, or penalty. No documentation. Paragraph 3 limits the defense relating to innuendos or inferences that are not supported by admissible evidence. Overly broad. Okay. Unsupported by factual allegations. State seeks to limit the defense's ability to conduct voir dire during the introduction of substantive issues in the case, to the jury pool. State provides no specific references. Overly broad. The state seeks to limit the defense's ability to question potential jurors about their feelings about the credibility of certain anticipated witnesses. State seeks to limit the defense from introducing hypothetical questions that include facts. Wow. State seeks to limit the defense's ability to challenge the geofencing expert, Kevin Horan, based on relevance. Yeah. You know what happened, Baldwin? They didn't just limit the defense to challenge it. They limited it altogether. They threw it out. Threw it out all the fucking together. As if who was there that day, and as if who left a mere 5 minutes after potentially plugging in a headphone jack into that victim's phone, as if that person was irrelevant, when there's a nexus in time and space. Think about it. There's a nexus in time and space to that headphone jack being activated at 5:44. The state seeks to limit evidence regarding to its failure to provide the defense discovery consistent with local rule regarding discovery consistent with Rule 2.5 Indiana Rules of Criminal Procedure. You hear what I'm saying? You hear what they're saying? They wanted to limit the defense being able to present evidence about the failure to provide discovery consistent with the rules. It gets worse. Oh my God, this one's even worse. State's motion in limine regarding composite sketches. Comes now the state of Indiana requesting the court prohibit the admission of or reference to composite sketches. Oh. For the reason that a composite sketch is not relevant, admission would result in undue prejudice, confuse or mislead the jury, or is impermissible hearsay. And the witnesses who participated in the preparation of these sketches will not be presented by the state for the purpose of in-court identification of the defendant, because they can't, because it ain't him. Now, can you believe the gaslight in this shit? Let me pull this down just to say this. Can you believe the gaslighting there? The sketches are not relevant, and admission would result in undue prejudice, confusion, or misleading of the jury. Not just that, the state will not present witnesses for the purpose of in-court identification. Yeah. You know why? Because they can't fucking do it. Listen, if those girls had seen Richard Allen's little ass out there that day, you don't think, let's take one of them. Let's take Betsy Blair. Even if she was lying, you don't think Betsy Blair could have said, hey, yeah, I saw him, Richard Allen. That little guy over there, that's who I saw that day. Oh, no? Oh, how about Rayleigh Voorhees? She couldn't have said, yeah, I saw him that day. Him right there. He's the one I saw. Well, I didn't see the face that clearly, but judging from the body, if he just stands up, I would say it very well could be him. No, not her. We had some other ones. The composite sketches were intended as an investigative tool to generate leads to identify a suspect. Well, that's always the case, isn't it? And in fact, these sketches were not related to the identification of Richard Allen. I think that's important for all the retards. By that I mean Troll Farm, Carroll County meth heads, who try to put up side-by-sides. Remember how Sleuth Intuition loves to cut out little Richard Allen's face and bobblehead doll it on top of his fantasy world, fictional, hypothetical scenarios that fantasize that Richard Allen Lone Wolf killed these girls? They love to put his little face, so they wanted to do side-by-sides of the bridge guys with Richard Allen. Hey, how many of you saw this? Did you see Doug Carter himself do it? Remember Doug Carter? So he's being interviewed, and somebody shows him the side-by-side with both sketches and Richard Allen's little face in the middle. And even Doug Carter says, yeah, like I've always said, Yeah, yeah. If you put both sketches, yeah, you put him in between. It's oh. But irrelevant, Doug Carter, that the witnesses who assisted in the preparation of composite sketches of Bridge Guy would testify they did not see the person depicted in their sketch for a sufficient length of time to allow them to identify the defendant. Then why in the fuck did they do a fucking sketch? Hold on. Hold on. Because we remember very clearly the witnesses did not want to cooperate. Remember, Jerry Holman revealed that. I've shown you the transcripts. Jerry Holman would say, it is true that the witnesses did not want to cooperate with the investigation. The witnesses also did not want to provide the sketches for law enforcement. And now you're admitting that the witnesses did not see the person depicted for a sufficient length of time enough to allow them to positively identify anyone? Well, how in the fuck did they produce a sketch that's in any way accurate? Because those sketches are like extremely detailed. A sketch is not a photograph. It's not a sketch. A mystery. I'm Doug Carter, man of mystery. James Bond, reincarnated. Doug Carter and tentacles in the shack. Sketch is not a photograph. It's not a sketch. It's not a photograph. It's not a sketch. You put him in between. Put him backwards, inside out, backwards. Not a sketch. Family. The embodiment of evil. So, number 3, that if the court were to consider the composite sketches to be relevant, the probative value is substantially outweighed by the unfair prejudice confusing the issues and misleading the jury. What? Are you telling me that those sketches would unfairly prejudice, confuse, and mislead the jury? Then what the fuck did you do to the public for 7 years? How many hours did we waste looking at those sketches, sharing them, talking about them? I swear, man, this is this has literally been like psychological abuse to the public for 7 years. You can't make this shit up. This has literally been psychological abuse of the masses, those following the Delphi murders. The composite sketches would be hearsay or double hearsay. It's the state's belief, which listen, the state does a lot. The state believes a lot. Everything's a belief. Just like Betsy Blair, who believed she saw Abby and Libby. But what she should have said is, I know that I saw Kelsey and Bree. But that would mean Kelsey's lying about getting out of that car and going walk with Bree. Couldn't do that. That it's the state's belief that the defense intends to use the composite sketches as demonstrative evidence and for impeachment purposes. Oh, they sure were. That the witnesses who participated in the preparation of composite sketches are not being called to provide in-court identification of the accused. Furthermore, no composite sketch was instrumental in identifying Richard Allen. Okay, obvious. The prejudicial effect of composite sketches far outweighs the probative value for in-court identification of the accused, and would likewise be inappropriately used to impeach a witness who is not presented before the jury to provide in-court identification of the accused. This is fuckery. There's no other word for it. I mean, there's another word. It's skullduggery. This is straight up mental fuckery right here. That Indiana courts have not addressed this issue or use of composite sketches. Indiana courts have excluded composite sketches that resulted from the use of victim witness hypnosis. Well, are you saying that somebody who produced a sketch was hypnotized? I don't think anyone was hypnotized. Come on, man. Other Indiana cases discuss or mention the existence of a composite sketch in the course of an investigation leading to probable cause to arrest, but no analysis of their use as evidence to impeach witness testimony. So basically, what you're admitting, you knew the sketches were bullshit. You knew the defense was going to call out these lying ass witnesses, and we're going to use the sketches to do that. You knew that those witnesses cannot, could not, would not, and will not identify Richard Allen as a Delphi murderer or the person they witnessed. Therefore, they had to go. And if we get Skip in here, he'll tell you one better. That those sketches had to be omitted, because if you bring those sketches up, you have to talk about one Daniel Pearson. And if you talk about Daniel Pearson, the entire fucking timeline crumbles. Oh, yeah. It does. So, question here, before we continue, sorry. Where is his right to present a defense? Let's see. He goes to someone that you now claim is Dan Dulin. Dan Dulin destroys the recording and the handwritten notes from that encounter. So now we have to take Dan Dulin's word for what was said. Okay. Guess we have to take the state's word on that. You say that this tip was lost somehow, even though you have a digital database. And before all of you people lose total control of Unified Command by losing the sheriff's seat, Kathy Shank, who knows Ron Logan, is affiliated with Ron Logan, magically finds a needle in a haystack as if by miracle. It's an absolute miracle. She finds magically, just out of nowhere, appears this sudden lost tip that was out of place and marked cleared, and she just magically finds that. And even though it's marked cleared, she brings it to Liggett and says, "This is important. This is your killer." And he says, "Yeah, it's my killer. Hey, thank God we've got a killer now." You get Holman to go in there says, I'm not going to arrest this guy. He gets the guy all riled up and then arrests him. Then Liggett lies and misrepresents witness statements and omits pertinent information in the PCA. Judge Diener signs it. He then allows Lesenby to move Allen to White County Jail without a safekeeping order. Lesenby then writes a safekeeping order or request to move him to custody of Department of Correction. He gives it to Judge Diener. Judge Diener says, no, that's not the way it's supposed to be. Let me write it for you. And he writes it. He then gives it back to Lesenby, who then gives it back to Diener, who then issues the order, knowing he shouldn't have, which is his second faux pas here. He blames the public for bloodlust for information because, zero transparency allowed in this crime. He then goes ahead and signs it, issues the order, and immediately resigns, again, blaming the public for bloodlust for information. Oh, and I didn't mention that none of this included the attorneys that he had or the attorneys he had requested. Indiana tramples man's constitutional rights. Memorandum of law in support of admission of evidence of alternative theories of the crime and third-party perpetrators. Mr. Allen has a constitutional right under the 6th and 14th Amendments of the U.S. Constitution and Article 1, Section 13 of the Indiana Constitution to present evidence attacking the credibility of the prosecution's case, undermining the believability of the prosecution's witnesses, identifying third-party suspects, and establishing Mr. Allen's theory of the crime. Oh, but here's one thing we know. In this courtroom, you're not allowed that. You're not allowed constitutional rights in Judge Gull's courtroom. I mean, this is a biased judge. She's already made up her mind. He's guilty of sin. He needs to go away forever. He's the killer of Abby and Libby. This right is the cornerstone of the adversarial process and essential to a fundamentally fair trial. And denial of this right constitutes structural error, whether rooted directly in the Due Process Clause of the 14th Amendment or in the compulsory process or confrontation clauses of the 6th Amendment. The Constitution guarantees criminal defendants a meaningful opportunity to present a complete defense. The right is accomplished through the right to offer testimony of witnesses and compel their attendance at trial. It's necessary for both the accused and the prosecution to present their version of the facts to the jury so that the jury may decide where the truth lies. Just as an accused has the right to confront the prosecution's witnesses for the purpose of challenging their testimony, he has the right to present his own witnesses to establish a defense. This right is a fundamental element of due process of law. When the prosecution seeks to prevent an accused the opportunity to present other versions or possibilities regarding the alleged crime, either through cross-examination or its own witnesses and exhibits, they are urging the trial court to commit not only an evidentiary error, but a constitutional error from which prejudice is presumed. Hernandez v. State. Similarly, the exclusion of evidence tending to show that someone other than the accused committed the charged crime is inconsistent with substantial justice and therefore cannot be deemed harmless error. Allen v. State. Thus, the question becomes, what type of evidence is so critical and unique to Mr. Allen's defense that the U.S. and Indiana constitutions, above and beyond Indiana rules of evidence, require its admission? The Indiana courts have answered that question by reversing cases when the excluded evidence challenged the credibility of the state's investigation and witnesses, presented an alternative exculpatory explanation of the state's evidence, or showed that someone else could have committed the crime. Can I say that again? At the beginning of the prosecution's motion in limine, at the hearing, Mr. Allen presented evidence that the murderers of Abigail Williams and Liberty German have ties to Odinism and were ritualistic. Mr. Allen also presented evidence that third parties are linked to the murders. The prosecution seeks to exclude evidence of third-party motive that is not relevant and/or the probative value is outweighed by unfair prejudice, confusion of the issues, or has the potential to mislead the jury in violation of Rule 401. That's from the motion in limine. Yes, he actually said that. The prosecution further requests in order to exclude testimony or evidence concerning Odinism, cult of ritualistic killing, Brad Holder, Patrick Westphal, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Klein, Tony Klein, and Ron Logan. The prosecution's requests seek to limit Mr. Allen's ability to present a defense, and I would say completely eliminate it altogether. And violate Mr. Allen's rights pursuant to the 6th and 14th Amendments to the U.S. Constitution, Article 1, Section 12 and 13 of the Indiana Constitution. Mr. Allen is entitled to present evidence pursuant to the 6th and 14th Amendments to the U.S. Constitution and Article 1, Section 12 and 13 of the Indiana Constitution that the crime has elements of Odinism and ritualistic killing. All right. The 6th and 14th Amendments of the Constitution in Article 1, Section 12 of the Indiana Constitution demand that the jury hear all versions and possibilities regarding the alleged crime. Can you hear that? Can you hear that? Demand that the jury hear all versions and possibilities regarding the alleged crime. That's Moore v. State, which held it was unconstitutional to prohibit a defendant from introducing a suicide note near a body and allowing the state to introduce death certificate stating homicide. Wow, that's rough. The state cannot take advantage of the inculpatory conclusion but prohibit the defense from placing the exculpatory conclusion before the jury. In this case, the prosecution argues that Richard Allen, acting alone, killed Abigail Williams and Liberty German. However, the evidence from the location where the bodies were found strongly suggests that more than one person was responsible for these murders. As a matter of fact, former ISP detective Kevin Murphy testified that it was always the belief of law enforcement that there were between 2 to 6 people involved in the murders. Hey, Prof says 6 to 14. Yeah, believe me. All right, so where do Kevin Murphy and Prof agree? Oh, we settle on 6. That's our nexus. If the prosecution's argument is that Richard Allen acted a fucking lone, and there are alternative theories that the murders were committed by more than one person, then who are the additional people involved in killing Abigail Williams? Yeah, good question. I hadn't thought of that. Until just now, this moment. If Kevin Murphy et al. Had always thought it's 2 to 6, and you want to stick with Richard Allen, okay, you can have Richard Allen. Who else? Who are the other actors? Which even McClellan mentioned. And like I've said, 0 defensive wounds. 0 defensive wounds. 0 defensive wounds. How do you kill 2 little girls brutally like that with no evidence of binding and leave 0 defensive wounds? No one can tell me. Not one crime scene tech in this fucking world can get over here and tell me how on earth you kill 2 able-bodied girls with 0 defensive wounds and no binding. No one's alleging that they were incapacitated by drugs or blunt force trauma. Come on, McClellan. Come on, state of Indiana. So you're not agreeing that they are bludgeoned and knocked out cold and then cut, okay? You're not agreeing that they're bound and then cut, okay? You're not agreeing that they're drugged and then cut. So you tell me, other than being held by multiple people, how on earth are they cut so brutally, one at a time, yet no defensive wounds on either girl? It's impossible. There's no way. Look, even the most fucking bold-faced liar cannot come up with a reason or way in which that could happen. You can try to lie all you want. There's not one person is gonna be able to get on here and describe to me how that's physically possible. It's a physical, listen. It's a human instinct to reach for that knife if it's cutting you. It's an instinct to reach for it before it cuts you. But at a minimum, when that knife hits you, you're gonna reach for it. Not a scratch on either girl's bodies. Either body. So who are the other people? The answer is that there are third-party suspects who have not been charged and who have no ties to Richard Allen. This leads to the conclusion that Richard Allen is innocent and that other individuals acting together killed those girls. Dr. Dawn Perlmutter, the director of Symbol Intelligence Group and adjunct professor of forensic medicine at the Philadelphia College of Osteopathic Medicine, who trains federal, state, and local law enforcement. Yes, she said Department of Homeland Security, FBI, state police, etc., etc. Testified that the murders were committed by individuals with ties to racist Odinism, Asatru, heathenism, call it what you will. These are polytheistic ideologies involving the worship of Nordic pagan gods. And I've said to you, it's co-opted. It's actually white nationalist terrorists who operate or they trade in drugs and humans, and they wear the Odinist or Norse pagan mask as a cover. If they're in the prisons, they just go by what they are. These ideologies are nature-based. Yes, like Satanism. They generally take place outdoors, incorporate natural elements like sticks and blood and sacrificial knives. By the way, why haven't we ever looked for that? They're typically performed near bodies of water. Both ideologies incorporate the use of runes, which are marks of mysterious or magical powers. Yes. And bind runes look kind of odd and they're personal to individuals. Don't you get that? Remember, Robert Ives said it was like something you'd want to take a picture or video of. Why the fuck do you think he said that? Runes take on additional magic powers when charged by blood or when two or more single runes are coupled together in a bind rune. Both ideologies incorporate magical thinking. She further testified that while Odinists have general shared symbols, such as Odin's hammer, they splinter off into weird-ass fucking little groups like we find, like the Venlanders, or like Pat Westfall's group, Brad Holder's group. Social media, meaning the fucking internet, has been a large part of this development as it allows individual access to a wide range of interpretation, symbols, and ideas. Yeah, remember, do you guys at all remember the guard at Westville who actually had an Odinist altar on his fucking Facebook? Are we just forgetting about that? Yeah, and then there's the one with the Odin patches, and the other one with the Odin patches, and the one with the Odin tattoo. We forget it, we forget it, we forget it, we deny it, we deny it, we deny it. Because we all know corrections officers are never involved in any bad activity, illegal activity, illicit activity, crime. All right. Dr. Perlmutter, remember her, she called this textbook, including the location of the crime. I'll go fast through this because I don't have my voice. It's not going to last long enough to get all the way through all of this. But remember, we've covered this before. All you got to go do is watch it. It's on the channel. I think I called that one maybe, who knows? I got one called Blair Witch. That's where I go through it. And I think another one called Symbolism at the Crime Scene. You go watch those if you want. But we talked about the location of the crime being near the body of water in a clearing, right? It's in a clearing on Ron Logan's near the body of water. I mean, come on, dude. I've been there. It's exactly what it is. Date of death, February 13. Okay, remember, sundown February 13 to sunup February 14th, the very fucking time of these murders, is Valisblot, a sacrificial feast. Remember, Mr. Labredo said one girl was killed and one girl was sacrificed. One girl was murdered as a killing. The other girl was sacrificed as a sacrifice. Cause of death. Dr. Perlmutter testified that ritualistic crimes are most often committed by sharp force injury to the neck. That slitting the throat is indicative of sacrifice. Both girls' throats were cut. And remember this. Remember this. Libby was killed at the scene. Her blood is all over the place. Pooling. There's an actual rune that matches the rune on Abby, a bind rune that matches the bind rune on Abby, placed over the large pool of blood. There's indication that she was walking around the crime scene, bleeding. There's indication she was sitting up, bleeding. That she possibly fell backwards, bleeding. Libby was alive and bleeding at the crime scene. It's my belief Abby was brought to the crime scene deceased and then cut in the neck. Do I have to say it again for the fucking idiots in the back? It's my opinion that Abby was killed elsewhere, brought to the crime scene, and then stuck in the side of the neck with a bladed weapon. Then Libby was killed while alive at the crime scene. Murder weapon. Ceremonial knives. Where's the fucking ceremonial knife? Symbols at the crime scene. Oh, yeah. Runes are often left at the crime scene. In this instance, there's what can be interpreted as a Lagus rune painted on a tree in Libby's blood. Yeah, that's the one that looks exactly like it's painted, like a right angle, and it's painted in the victim's blood. And your stupid ass crime scene examiner wants you to believe that it's a handprint. Literally expects you to believe the impossible, that it's a handprint. It's not a handprint. Perlmutter testified that sticks and branches laid on the bodies are deliberately and intentionally placed. FBI Special Agent Nicole Robertson, remember I was referring to her earlier, testified when she was searching the home of Ron Logan, she was looking for evidence of runes and anything Nordic. I mean, goddamn, FBI was looking for runes. Emails between FBI and Doug Carter provide evidence of the belief by law enforcement that evidence left behind, including sticks found on the girls, were supporting the possibility that the killers were Norse paganists. Yeah, Doug. Yeah, Doug. Number 5 here. Oh, let me turn the page. Okay, here. Again, emails between FBI and Police Superintendent Doug Carter show evidence of belief by both of them that the sticks supported the possibility the girls were killed by Norse pagans. Are you fucking kidding me? What happened to all that? Body disposition. Remember, I showed you in my symbolism at the crime scene. I explicitly showed you how I believe the bodies were disposed or staged into figurations that appear to be mimicking of 2 tarot postures. Perlmutter testified that bodies are often moved and positioned in a fashion not counter-forensic. And that they often include the arrangement of natural objects. Nicole Robertson, FBI special agent, testified it was her belief that Libby and Abby's bodies had been moved and staged. Major Cicero, the same one who says it's a fucking handprint on the tree, testified Libby's body was drug around the crime scene and Abigail's was moved. And remember, Robert Ives said they were moved and staged. The sticks and branches were deliberately and intentionally arranged on the bodies. Just look at the crime scene photos. Major Cicero agreed that at most 3% of the girls' bodies were covered. He also agreed that there were many leaves and sticks that could have been used to conceal the bodies if that was the intent. Oh, but the troll farm will not agree to that. Oh, they'll argue to their deaths about that. Oh no, Prof. Oh no. Oh no, there was leaves. Those sticks were to cover the bodies, Prof. Atypical blood pattern. She testified there's often atypical blood pattern and that the blood pattern on Libby's face is atypical. Major Cicero agreed to an abnormal pattern on her face. Mr. Allen has a constitutional right pursuant to the 6th and 14th Amendments of the U.S. Constitution and Article 1, Section 12 of the Indiana Constitution to present evidence of such. Don't you know that this court didn't allow that shit? The 6th and 14th Amendments to the Constitution and Article 1, Section 13 of the Indiana Constitution protect his rights to challenge the manner, quality, and thoroughness of the investigation, and inquire about law enforcement's failure to consider third-party suspects and present evidence of a biased investigation. Mr. Allen has a fundamental right under due process to offer or to call law enforcement officers as witnesses and to cross-examine them on their failure to properly investigate or consider third-party suspects. The fact that an investigator may have discounted a viable fact, or how about deleted 70 fucking days of facts? Oh, but that doesn't count, right? It's Delphi. Or an investigator may have discounted a viable suspect, makes it more probable that the investigation was flawed. Oh, but not this one. The Delphi investigate. Hey, let's do this. Don't you realize that the Delphi investigation was perfect, just like the families are? Everyone's perfect in this fantasy world. I mean, the investigators, every single cop, 0 mistakes were made. The prosecutor's perfect. The judge is perfect. The judge's assistant is perfect. Remember that the troll farm harassers, death threateners, and stalkers are perfect. The families are absolutely perfect. Not one felon in that family. And the victims were perfect. We know that. They were little angels. They never did anything inappropriate or caused any sort of targeting. Oh, we know every one of these witnesses are perfect. Mr. Allen also has a fundamental right to impeach the credibility of and present the bias of any witness, including law enforcement. A witness's bias, prejudice, or ulterior motives are always relevant at trial in that they may discredit her or him or affect the weight of his or her testimony. Remember that? It's been well established that law enforcement, like all humans, can suffer from confirmation bias, tunnel vision, etc., just like everyone involved in this prosecution. In other words, a detective or officer or prosecutor may search for, interpret evidence in a manner that confirms his or her existing beliefs. In this matter, Mr. Allen's evidence is that law enforcement failed to properly investigate third-party suspects and failed to consider alternative theories of their fantasy world timeline. In this case, members of Unified Command failed intentionally, in Prof's opinion, to follow up on leads and investigations of Assistant Police Chief Todd Click, and then they went in ahead and arrested him because they didn't like him. And Indiana State Police Detective Kevin Murphy, because they didn't like him. And Officer Greg Ferenczi, because they killed him. Such as the failure to extract Brad Holder's phone, or in the fucking family, the failure to investigate Patrick Westfall or Elvis Fields, or the failure to seek warrants or search the homes. Unified Command did not consider the fact that any fact that did not fall into their timeline. Unified Command failed to investigate why Libby's phone suddenly connected to the tower as if it was turned on at 4:33 in the morning. Remember, at 5:44 p.m., it stopped connecting with the server, which is the exact time that a headphone jack was activated. Remember, someone left the geofencing a mere 4 minutes later. Remember, 10:32 p.m., something is unplugged from that headphone jack. Excuse me. Excuse me. Hold on. Remember that those searchers were sent home, at least the ones outside of our control were sent home at that time. And remember, certain parties stayed there. Remember, those girls were not found for some 19 hours. Inexplicably, when it was full of searchers. And suddenly, in the 2 a.m. hour, 3 young ladies hear blood-curdling screams. They call law enforcement, who says, "Sorry, we're busy. We can't investigate." Then magically, 2 hours later, the phone comes on. Well, shit. Jerry Holman claims that there's no evidence Richard Allen was at the location anytime after 3:30 p.m. Well, something happened at 5:44. Something happened at 10:32. Something happened at 2 a.m. Something happened at 4:33 a.m. So who was there? This evidence goes to the very heart of the thoroughness of the investigation into the deaths of these 2 girls. Mr. Allen's rights, his constitutional rights, required that this evidence be admitted. That's the 6th and 14th Amendments to the U.S. Constitution, and the 12th and 13th sections of Article 1 of the Indiana Constitution. The 6th Amendment to the U.S. Constitution and Article 1, Sections 12 and 13 of Indiana Constitution protect defendant's right to present evidence that someone else committed the crime. Evidence which tends to show that someone else committed the crime logically makes it less probable that the defendant committed the crime, and thus meets the definition of relevance in Rule 401. You see that down at the bottom? When the state excludes competent, reliable evidence that is central to the defendant's case, his constitutional right to present evidence is abridged. Indiana courts have found the following evidence to be competent and reliable. Evidence central to the accused defense that someone else did it. And then there's a bunch of examples we'll skip over. Understanding that evidence of third-party suspects is relevant, the question then turns to the standard the court must utilize in determining whether the third party evidence is admissible. As the Indiana Court of Appeals has stated, to be admissible in a criminal prosecution, read down here at the bottom, evidence that a third party has committed the crime with which the defendant is charged need not show substantial proof. This is about the nexus. Please pay attention. Of a probability that the third party has committed the act. It needs only be capable of raising a reasonable doubt of the defendant's guilt. While a criminal defendant may present alternative perpetrator evidence at trial in order to cast doubt on the defendant's guilt, the defendant must first lay an evidentiary foundation to establish that the alternative perpetrator evidence has an inherent tendency to connect alternative perpetrators to the actual commission of the charged crime. Here, Mr. Allen's evidence of third party falls well within the category of competent, reliable evidence central to his defense that he is innocent and that other people committed the murders. Mr. Allen's evidence has an inherent tendency to connect third party suspects in the commission. And here we're going to briefly go over these. Look, I mean, this is bad. This appeals court better fucking man up. They better man up. This was absolutely an unconstitutional denying of his ability to present third-party evidence and a defense. Brad Holder is connected to the victim in this way. He's the father of the boyfriend of Abby Williams. That's a connection. In fact, he had met Abby Williams several times and lied about the fact. In his first interview with law enforcement, Brad Holder told officers he had never met Abby Williams. In his second interview with law enforcement in 2023, he claimed he had difficulty remembering which girl Logan dated. Do you really believe that? Despite the fact that the girl Logan dated had been involved in a high-profile murder case, Abby Williams. Holder remembered in this interview that he had supervised one date between Logan Holder and Abigail. He then told a third different story as to how many times he met Abby Williams when he was deposed in May of 2024. In the deposition, he claimed he had met Abigail twice, including once at a third-party suspect. Unfucking believably, Pat Westfall's. Yeah. Could it not get any fucking weirder? Which then connects Pat Westfall to Abby Williams. Patrick Westfall never admitted to the police that Abby Williams had been to his house. Then it talks about Brad Holder's Facebook, which was full of sticks formed with runes, or runes formed with sticks formed into runes. I've shown those to you before. And then there's Amber Holder's testimony that Brad Holder cut his hand and allowed blood to drip onto the Odin altar. She also testified Brad took her hand and cut her hand to drip blood onto the altar. Remember, the marking on the tree is in Libby's blood. We know that Odinists mark trees with blood. Amber Holder testified that Brad Holder told her that Patrick Westfall and his crew murdered Abby Williams and Liberty German. Do you fucking retards in the back need to hear that again? Amber Holder, who is Brad Holder's ex-wife, testified that Brad told her that Patrick Westfall and his crew, was his crew the Kokomo crew? Was his crew the Kokomo crew? But fucking dumbasses in the back. I'm sorry. Wake up. Wake up. Brad Holder told Amber Holder, allegedly, that Patrick Westfall and his Kokomo crew murdered Abigail Williams and Liberty German. Doesn't Richard Allen have a 6th and 14th Amendment right to present this to the jury? The fact that Brad was pointing the finger at Patrick Westfall? Or maybe it was both, or all of the above. Also, Amber Holder testified that Brad and Patrick Westfall had a falling out over something that happened in the woods near a river involving blood, wherein Patrick Westfall wanted to move on from animal sacrifice. She also testified that Patrick Westfall and his crew killed the girls because of Westfall's belief that Abby Williams' mom was a race traitor. Race traitor. Also, inward lover. Can we be real here? Dr. Perlmutter also testified that individuals adhering to the white nationalist version of Odinism would kill others because of their belief that someone was a race traitor. Furthermore, Amber testified that Holder told her that Westfall wanted to move on from animal sacrifice to human sacrifices, and this was the real source of the falling out between Holder and Westfall. Of course, Holder denied making these statements. Jerry Homan testified that Brad Holder had an alibi, right? Of course. We're going to skip ahead about the phone. They talk about the phone. You already know. I've already mentioned all about the phone. Let's go to Pat Westfall. Westfall was at home. Where, Prof? Near the Monon High Bridge. Where is Westfall's home, Prof? Near the Monon High Bridge. Prof, does Patrick Westfall live near the Monon High Bridge? Near the Monon High Bridge. On February 13th, he was home near the High Bridge. There's no proof of his whereabouts other than his statement. Brad Holder and Patrick Westfall knew each other from Afghanistan, where they served in the army. They practiced asatru. They were members of a small kindred group, people who believe in asatru and gather every Sunday to hold fucking meetings. Patrick Westfall considers himself a priest or holy man in asatru and hosted these meetings in his home in Delphi, near the Monon High Bridge, on Sundays. Brad Holder attended those meetings. Let's go on. Elvis Fields. Elvis Fields knew Brad Holder. He mimicked Brad Holder's Facebook posts. Todd Click testified that Elvis was a suspect in the murders, and he was interviewed several times. After one such interview in which they took DNA, Kevin Murphy drove Elvis home. Detective Murphy testified that after Elvis got out of his car, he returned and asked Detective Murphy if his spit was found on one of the girls, but he could explain it. Would he still be in trouble? Elvis Fields lived in Rushville. If he spits on one of the girls, this places him in Delphi at or around the time of the murders. Elvis Fields' statement is admissible pursuant to Indiana Rules for Evidence 803.3. Under this rule, a statement of the declarant's then existing state of mind or emotional, sensory, or physical condition is admissible as an exception to the hearsay rule. Elvis's statement is clearly indicative of a guilty state of mind and indicates he has a mental feeling of anxiousness. Finally, Elvis's question to Detective Murphy was precisely that, a question. Hearsay is a statement. Rod Abrams is a friend of Elvis. In his statement, Rod Abrams testified that at the time of the murders, Ned Smith drove a white pickup truck. And also, Elvis Fields drove a white pickup truck. Tina Garrison saw a white pickup truck at the old CPS building. Have you forgotten about that? At 4:20 on the day of the murders, Tina Garrison was tendered near the end of the day as an exhibit on August 1st, 2024. Given that both Elvis and Ned Smith drove white pickup trucks, this potentially places them in Delphi near the scene of the murders on February 13, 2017 at 4:20 p.m. Remember I said all the vehicles that were omitted from this case? It's absolutely unbelievable. There was a handful of trucks, of vehicles. Sorry, shit, I'm getting tired. Handful of vehicles were omitted from this case, believe it or not. Finally, Elvis's friends, Rod Abrams and Ned Smith. Sorry, I may have skipped page unintentionally. Let's see. Could not keep their story straight concerning their whereabouts with Elvis. According to Todd Click and Kevin Murphy, and probably the deceased detective or agent Greg Ferenczi, who was murdered, Abrams told different stories as to his whereabouts with Elvis. In one story, he claims Elvis and Ned were all in a Muncie hospital. Abrams admitted having his phone on him while in Muncie. However, when pressed whether his phone pings would verify, Abrams stated that the hospital equipment would likely block his phone's locations. During deposition, Rod Abrams testified he did not believe he even owned a phone in 2017. While Abrams and Smith claimed that Elvis was with them in Muncie on February 13, Elvis denies that he ever left Rushville. Detective Murphy testified Elvis's phone records show a man who constantly used his phone on any given day, but he did not use his phone on this day between 10:30 a.m. and 7:30 p.m. Where the fuck do you think he was? That's 9 hours. All right. Now, it's not over. It's not over with Elvis, because there's something I want to tell you. That's it's not necessarily in this document. I have to refer to the Frank's memorandum, which I will do for you because I am thorough for you. So just a minute. A minute. I believe it's page 75. I'm starting to have memorized the actual pages of this Frank's memorandum. Watch. I believe it's page 75. Let's go to there. Page 75. I'm starting to memorize these pages, is what I'm getting at. But on page 75 in the footnote, no, it must be 77. No, it's 73. 73. Okay, on page 73 in footnote 91. Listen to this from Elvis. Again, this is Frank's memorandum, page 73, footnote 91. On October 24th, 2017, Elvis told his sister, Joyce Moffett, quote, "I am in trouble. I am going away for a long time. I was on that trail and that bridge with those girls when they were murdered. There were two other people there with me when it happened. I spit on one of the girls after they were killed." Close quotation. That's supplement 542, Joyce Moffett interview, exhibit 44. That's page 73, footnote 91. Again, remember, Jerry Holman has tried to tell you, he tried to come out and say after trial that Elvis meant if someone scooped up some spit, Elvis was afraid someone scooped up some spit and threw it on one of the girls' bodies. Sounds like what Elvis actually said was, "I am in trouble. I'm going to go away for a long time. I was on a trail and that bridge I was on that trail and that bridge with those girls when they were murdered. There were two other people with me." Who was there with you, Elvis? "I spit on one of the girls after they were killed." But we're going to pretend we don't know about that, right? We're pretending we don't know about that. Because he's just Elvis Fields and we can make up his own words. And remember, Stephanie Thompson was killed after doing the polygraph with Elvis's sisters, who both snitched on him. Let's see. I'm on the trail. Let me pull this down. I was on that trail, on that bridge, with those girls that day with two other guys. Who are the two other guys? Johnny Messer is also a suspect in this case who connects to the Delphi crew of Brad Holder and Patrick Westfall, and he connects with Elvis Fields, Rod Abrams, and Ned Smith. There are pictures on social media of all of them together at an Odinist gathering. Brad Holder, Pat Westfall, and Johnny Messer. Kevin Murphy and Todd Click testified as to the connection between them, the three. That Holder, Westfall, and Messer were all associated with the Vinlanders. Did I lose my page again? All right. Messer was a recruiter in the Vinlanders. Okay. Now, the fact that Messer's former girlfriend, Taylor Hornady, told Kevin Murphy that around Valentine's Day, you remember that's the day of the Delphi murders, in 2017, Messer was up there visiting his Vinlander friends, meaning in Delphi at Westfall's house. And that a red substance she believed was blood was found on the car he drove up there. Remember that story? That he took the car to go up there to Delphi with those guys, and when he returned, it was full of blood. It took several washes to wash off. Keegan and Tony Klein. Remember this? We covered this yesterday or day before on the Anthony Shots. Keegan was communicating with Liberty German and Abby Williams under the name Anthony Shots and with some other user. Keegan Klein admitted driving to Delphi with Tony Klein in a car, not a Jeep, and that Keegan waited in the vehicle 2 hours while Tony Klein went into the woods with someone else where on Ron Logan's property where the bodies were found. He waited in the vehicle in the cemetery, and that when Tony returned, he had blood on him and said, "We had fun." Roland Purdy further testified that Keegan admitted they discarded a knife in a river. And I showed you yesterday or day before on the Anthony Shot show where I thought that knife was disposed of. So they looked in the wrong spot, in my opinion. The bodies of Abigail Williams and Liberty German were located on Ron Logan's property. Here's Ron Logan. Ron Logan lied about his whereabouts. He had a false alibi. Remember, he visited the dump and threw away a whole bunch of trash which could have contained evidence. Again, the mere fact that those bodies were found on his property should have been reason enough to be able to mention his name. Richard Allen has a right to introduce evidence of motive. Okay? Part 3 here. In the context of third-party motive evidence, an accused must show some connection between third party and the crime before evidence is admissible. In this case, the prosecution has no proof of any connection of Allen to Abigail or Liberty, nor have they identified any motive as to why Allen would kill them. Well, now they say he got sexually perverted and wanted to have sex with them. Now, what do you think? Is there motive for Richard Allen to kill these girls just in the middle of wide open, broad daylight to suddenly want to bring them under the bridge to sexually assault them? Or do you think there's more of a motive and more evidence that Patrick Westphal, Brad Holder, Elvis Fields, and others, Patrick Westphal and his crew, maybe the Kokomo crew, maybe a bunch of meth cooking Satanists, maybe a bunch of fucking white nationalist fucking Vinlanders? Who knows? I mean, have we forgotten that there's someone named Gabe Ellis? Gabe Ellis was involved in the drug trade with a whole bunch of people. There's someone named Megan Allen who is connected to Gabe Ellis. Megan's mother snitched her out real bad after these murders. Megan said she stabbed Abby in the neck to see what it would feel like. At the same place, at the same time, while being initiated into a gang. Her mother, Tina Rodell, ran all over the internet telling this story. There are hundreds of receipts. Her mother named all the individuals involved, including a Garrett. These people connect to Christy Lynn Martin, who was a supplier, a major connect for these dealers. Well, how do you have this whole big group of people initiating, cooking meth, smoking meth at this time and place, out on this specific day, raping, killing, sacrificing, initiating? Doesn't that seem like the type of place two little girls might get murdered? I mean, one of those victims has a father who was dealing for these people. I mean, it almost has the scent of an Outlaws affiliated versus Hell's Angels affiliated crime, does it not? The thing is, all these people came out talking about it in the years after these murders until they realized people were screenshotting. And as I mentioned before, that entire area, Ron Logan's, all of the Mears properties, and the Weber's properties, was infested not only by drugs, but by these very people. They ran amok up and down that creek from Wilson's Bridge to High Bridge. Cooking dope, shooting guns, fishing, hunting, camping, sporting. Where's our defendant's constitutional rights to present at least a portion of that evidence to the jury instead of keeping them blindfolded, shackled, deaf, and dumb, ignorant to any context? For reasons identified above, Richard Allen respectfully requests the court deny the prosecution's motion in limine as it relates to Odinism, cult, or ritualistic killing, Brad Holder, Patrick Westfall, Johnny Melsa, Elvis Fields, Ned Smith, Rob A. Abrams, Keegan Klein, Anthony Klein, Ron Logan, and for all other just and proper relief in the premises. Now, do you believe that this judge respected those heavy 27 pages? No. She summarily denied and granted the motion in limine so that none of this could be mentioned. Which is why, as our juror indicated, when this jury came down to decision, they basically had only one choice. You convict this guy right here, convict him. Richard Allen, your one choice. Or Libby and Abby will never get justice. Now I ask you out there, you supposed believers in all that is true, just, and right, is this kind of justice true justice for those girls? This kind of justice, the world will never be satisfied with. Their names will live in history as controversy, as the epitome of corruption, as an example of injustice. Is that the way you'd want your daughters to live in people's memories? See, we expected better out of this. So many of us We've followed since before Richard Allen was arrested, before he was known. So many of us, we've followed since day one. We wanted true justice for those girls, which means the truth be told about them. I ask you, do you feel the truth's been told about those girls? Even worse, what about the 4 in Flora? Do you feel the truth's been told about them? People wonder why we shame this community. We shame this community because we look at it and we say, what kind of community would be okay with the killing of their own daughters? And the answer is no kind of community would be okay with the killing of their own daughters. And all we've seen all these years is a bottomless pit of corruption and money. For years, we've watched thousands and millions of dollars be sucked down into this hole. And the community is okay with that, and they're okay with this. And we look at this and say, how could you be okay with that? And if you truly believed Richard Allen was guilty of involvement in these murders, wouldn't you want it done so that it's proven without controversy, with finality, resolution, convincingly, such that it brings peace and those girls can rest in eternal memory peacefully? To honor their names. Surely that's what anyone would want. So why don't you? Do you think that Greg Ferenczi was living his life in vain? Do you think that he wanted to waste his time and energy and didn't care about justice for those girls? Do you really believe that Todd Click does not want justice for those girls? Or how about Kevin Murphy, Stephanie Thompson, everyone who did the actual work? You think they didn't want justice for these girls? Because it's sure how you portray things out here on the internet. I think they did good work. You just didn't want to hear it. You forced it your way. And now look at what you're left with: controversy, scandal, talk of corruption, collusion. No one's convinced. I'd be willing to bet even those jurors are not convinced. Kind of seems like they just did what they have to do, what they had to do to make it go away. And this man's constitutional rights. Listen, I know we've just spent 4 hours trudging through all of this. I could have summed it up in 2 minutes like this. You know where his constitutional rights ended? Westville. Should have never happened. He should have never been put in Westville. Should have never been put in solitary confinement for, was it 13 months in Westville? And then another 10 Cass County. And where he is right now. You see, as a pre-trial detainee, shouldn't be allowed. Was it Geneva Conventions or we cannot treat prisoners of war the way that Mr. Allen was treated as a pre-trial detainee. In other words, what does detainee mean? You're being held and you've arrested in lieu of arrest, or you're being held a little bit. A little bit. You're being held for a little while. Pre-trial detainee. I've said before, you know what has to come from this? Another law. We need Allen's law. That you cannot take a pretrial detainee and throw them in prison in the hole until they damn near die to give you your confessions or your plea deal, whatever the fuck you want out of them. This should never be done to another human being in the United States of America ever again. Pretrial detainee thrown in prison? No. Put them in a little jail, keep them safe. But I'm a dreamer. But luckily, like the song goes, but I'm not the only one. So hopefully our dreams will someday pan out and we'll figure out, how do we treat people? How do you allow the power, the state, with all the power that's behind it? Remember, think about it. How much power is behind the state? Pardon me. How do we allow the entire weight of the state of Indiana to be thrown down onto one man, and all he has to fight back with is $5,000? 5,000 versus 4 million. Should have never happened. And It's my hopes that in this process of appeals, the appellate attorneys and courts will make this more right. And it's my hopes that the feds take a good look at this and do something about it. And hey, I'm serious. I've been serious when I've said write your politicians. I've given the advice so many times. Even if you write a single letter and send it out to all of your politicians, let them know your deep concerns. Otherwise, how do they know if you don't let them know? Because certainly their concerns ain't your concerns unless you make it that way. All right, so I want to say thank you. I just saw a super chat. Who was that? Because I'm getting out of here. Tracy Thornton, $25 super chat. Free Rick Allen is what she says. I mean, clearly there were things that were not right. And I've said it before. It could be any of you, any of us. But that's it for us tonight. If you missed the Stacey Eldridge interview on Rick's channel, please go watch Stacey Eldridge. It's pretty good. I'm doing a deep dive on a couple other things right now, so that will be what's up next. Hey, it's the end of January. So we have a really special February coming up. And so I'll be celebrating all month, February. So please do that. Oh, listen, commercial on the way out. For those of you who appreciate the channel, please know we have a Cash App pinned up at the channel, Cash App, and a Buy Me a Coffee. If you'd like to donate to me, I especially love the Cash Apps because they take less of a percentage of the amount that you are sending. So please send a Cash App if you'd like to donate. There's also the Buy Me a Coffee and the Super Chats and stuff. And I want to thank you for supporting the channel in those ways, as well as by hitting the like. And if you're on replay, please hit the comment section down below. I love the comment section. Comment section down below keeps the interest in the conversation going after the live is over. And it's about to be over. So appreciate all of you. And look, everyone who was here for the live discussion, thank you so much for participating in the live chat. I've been looking at it as I've been talking. It's been great. Okay, great discussion tonight. I'm all burned out. My ear is still stopped up and hurting. Hope I don't get a fever because of it. And my throat's going. So I'm ready to relax, get to bed, and I'm going to check in on that horrible plane crash that has happened in Philadelphia. It's really sad to see. Anyway, I'm upset that I couldn't gift you all of the memberships I would have liked to gifted you, but I just couldn't figure it out. But big special thanks to Jake Brooks. Okay, Mr. Jake Brooks here gifted 20 memberships. That's a lot of memberships for you guys. So thanks so much for gifting the 20 memberships. And someone else gifted 5. What was it, Tracy earlier? So that's 25 memberships for the chat tonight. So I so appreciate Tracy and Jake Brooks for gifting the memberships to our chat. I appreciate that. And hopefully all the chat who received them will go watch the train guy video I have up. I love that video. So anyway, God bless all of you. Hey, Rolo. Yeah, I agree. I see your comment. I am infuriated by that. And I've been waiting for more disclosure, but no, it's clear that the helicopter crashed into the plane. If you notice the flight path, it takes a turn and goes beeline for the plane and impacts it. I'm wondering what happened. I'm wondering what happened with that, but that's a whole other subject. Mainstream media, it's always going to lie to you. Um, do watch the train guy video. Trust me, you'll walk away more concerned about this case. But no, law enforcement I don't think has ever done anything right in the Delphi case. I mean, from day one, it's been all a complete incompetent shit show and possibly a cover up. It's horrendous. This thing, there's no way this should be allowed to stand. But God bless all of you. My throat is going, and like Sweet Dude Shibby says, hide your wives, grab your pickles, and enjoy tonight. Okay, it is Friday. God bless Friday nights and weekends. We love them. Anyway, God bless all of you. God bless Libby and Abby, or Liberty and Abigail. We do love you, and we appreciate you, and we're working for you. Anyway, that be a gun, and we're out.